During public input, I'm going to invite members of the public to come sit in this first seat here. We're finding that the sound is not great for some reason from the podium. So when it's your turn to speak, please come sit at the front table here. Once public input has concluded, I will take no further testimony or evidence from the public. At that point, we'll go back to the parties and they will have an opportunity to address questions and concerns raised by members of the public and put on any rebuttal testimony they wish to put on, and then their closing remarks. I don't believe we're going to conclude the hearing today. I just pass this along for those of you who are in the audience that may not be familiar with the process. I understand that certain members of the public have requested to present testimony in a specific order. I will honor that. I see that I've been provided with an updated list for today, and I will abide by that list. Finally, once the hearing begins, we will recess approximately every hour and a half to give the court reporter a respite. We will resume promptly after that break and continue throughout the day in that manner. I will break for lunch, as I anticipate this hearing will continue throughout the whole day. The lunch break will be about an hour and 15 minutes, and then we will resume promptly at the conclusion of the lunch break. We will terminate for the day at 4 p.m. We will resume again tomorrow at 9 a.m. and continue until 4 p.m. that day if necessary. I'm going to ask everyone to please take a moment, double check your mobile devices. Please place them in the silent or vibrate mode. And members of the public that are here today that wish to testify, I'm going to administer the oath to everyone en masse. Please raise your right hand. Do you swear or affirm the testimony and evidence you place into the record will be the truth?
Yes, I do.
Okay, thank you. Richard Grosso.
Thank you, Madam Hearing Examiner. I've got some documents I'd like to present to you before I begin my presentation. At the beginning of this hearing, back last month, you asked me to hold off until now to put into the record the request for party status for the CCA. So I've got that. Thank you. I've got that. I've got a letter of the legal analysis and attachments that I'd like to put into the record with copies for all others, if I may.
Okay, you know I've ruled on this, right?
Yes, I know
Okay.
you ruled, but you had just told me wait to put it into the record.
Yes,
until
please.
now.
I will accept that now. This is a composite exhibit?
Yes, ma'am.
Okay.
Thank you.
So, okay.
Can I inquire as to whether this is the letter dated February 11th that went to Joe Adams, or is it yes? Thank you.
Madam Hearing Examiner, was that a hard no on the stand at the podium? Doesn't
Well,
sound
we
good?
can try it. If we get raised hands and people can't hear, well then let me just mark this exhibit before you begin.
Can I ask a question, point of order for Madam Hearing Examiner, Mr. Grosso? On page 8 of this document, there's a list of documents that Mr. Grosso submits they may submit into evidence, whereas there's no foundation for any of those documents. Are you assuming they're automatically in evidence, or are you going to address it when you actually submit them?
In response to counsel, Madam Hearing Examiner, when that letter was written, it was obviously prior to the hearing. Those documents that have already come into the record have. I've got 2 additional attachments, or I've got my letter and 2 references in my letter that I've presented into the record now. And then there were, I forget what number of attachments to the letter, the February 11th letter itself. So anything that was in the may be introduced list that hasn't been is obviously not being introduced.
Okay,
other
that's
than what
I
I've
wanted to
given.
confirm. Okay, thank you.
So those items are not included in this composite. You've got them on the side and you may enter them?
It's either in the composite that I've handed to you and counsel now, or other people have already put it in and I had no need to put it in. If that.
Well, for example, one of the things is you have excerpts of testimony from another proceeding where,
And that particular document is in the composite exhibit that I've placed into the record.
well, and so I object to that because the county and the applicant objected to it at the DOA proceeding. It's not subject to cross-examination, and so that excerpt should not be accepted without some discussion about that. Well, and you also have a video, and again.
And the video I have not put into the record.
Okay.
The testimony excerpts are from county staff persons that address the status of the ADD, which you've heard a lot about, and that it hasn't been amended. That's Mr. Dunn, who testified that it was the governing document. It had been codified. It never was amended
Right,
to
it's
increase.
subject to amendment by virtue of this proceeding now. That's what this proceeding is. It's going to amend that ADD. So
yes,
I
but
recognize that the ADD represents a crystallization of the current development entitlements on the property.
And the point I was making was that his testimony is that up until now, it had never been amended. There had never been an amendment to the ADD that increased that 912 number. That was the specific point I was making about his testimony here.
Okay, Neil, with regard to documents that are submitted in this packet, the scope of my review is informed by the Land Development Code and the LEAP plan, and I will look at this evidence and I will afford it the weight that it should be afforded. It's tricky here because the traditional rules of evidence don't apply, but I am limited to some extent by virtue of my authority to review zoning applications. So I don't know if that gives you any comfort. I'll note your continuing objection, however.
Okay.
And obviously, you know, information, testimony, letters from individuals that aren't present and can't be subject to cross-examination, you know, that it's informative, but it's not, doesn't have the same weight as if they were here testifying. You know that.
Very much understood, and to be very clear that Richard Grosso speaking on behalf of CCA, our arguments are that the plan and the code is violated. We're not asking you to enforce anything other than the plan and the code. And as to county employees who aren't here, obviously the nature of this hearing doesn't allow us to subpoena or compel the attendance of people. I think that's why the rules probably grant some latitude.
Understood. And I'm going to let you begin. And if you have
You'll
an
note my
objection,
continuing
you can
objection.
voice-
Okay,
right,
thank
you
you.
can voice it, and then we'll just continue on.
And thank you. That was all I had in terms of preliminary matters before I make my
Okay,
presentation.
so
And-
will there be additional exhibits beyond these?
No, ma'am.
Okay. I'm just going to clip them. Maria?
Yes.
Okay.
And can you hear me okay? Thank you.
Didn't everybody hear all right? If you can't hear, raise your hand during the course of the testimony. Please do not call out. Okay, go ahead.
Thank you, Chief Hearing Examiner Collins. My name is Richard Grosso. I'm an attorney, and I'm here on behalf of the Captiva Civic Association, and I'd like to present to you a legal analysis based on the record that's been created throughout the application and submittal process, and obviously during the process over which you are presiding today. And the conclusion that we think is clear is that this applicant cannot meet its burden of proof, that the rezoning complies with the LEAD plan and the code. We believe the facts and the law allow only a conclusion that a denial must be recommended. If this applicant applied today for 272 units or 912 units on the entire 304 acres, 272 on its 120 acres, it would not be allowed. You heard Mr. Gauthier speak about this, but it's vested.
It would not what?
It would not be allowed.
Okay.
But it's vested because it was approved and it's almost completely built out. And so the LEAD plan with the property rights element, with the community plan policies, recognizes and vests that previous existing development as the historic development pattern at South Seas Island Resort. The applicant knew that when they purchased this property, but the law clearly gives them that vested right to continue that and not be subject completely to start over to the modern plan. There's no possible view, we believe, of the facts or any possible interpretation of the plan under which today, under the modernly planned 912 units could be permitted in this particular location. This application, to increase what's there already, violates the plan and the code on density, intensity, compatibility, protection of development from coastal hazards, from evacuation, unsafe evacuation times, adequate public facilities requirements, and environmental requirements. It's too dense. It's too much for this shrinking landmass. I remind us of sea level rise. For this particular piece of earth, at a coastal barrier island at the northern tip of Captiva, as far away as you can get from a safe place of evacuation. Conditions won't do it. There are no conditions that can overcome the sheer density and intensity of this project and make it permittable. I'll address the merits in a moment more in depth. As a preliminary matter, I think there are two issues that go to the basic sufficiency of the project. The first is the failure to comply with Land Development Code 33-16-12 that requires for a rezoning or planned development rezoning a community meeting. Mr. Mintz addressed that in his presentation to you, that there was no such meeting. There is no record of such a meeting in the record whatsoever. There was instead some sort of open house that did not meet the requirements for that type of a meeting. Now, the applicant's argument is that they are exempted from that by virtue of a recent ordinance that exempted them, that exempted development from everything in Chapter 33. Our position would be that that does not exempt them from the precondition procedural requirements for a community meeting. That's not development, that's a process. That's a mandatory procedure that has not been met. The second fundamental insufficiency problem is the applicant doesn't own all the property that it is for which it is seeking rezoning and deviations. Ms. Berkey made a presentation to you. Mr. Patterson and Mr. Witt made presentations to you that make it clear that on the face of the application and the applicant's own submittals, there's deviations that would apply to roads that the applicant only owns a portion of, and other people, other property owners own portions of that road, yet they're seeking a deviation for standards that would apply to that access road. They can only apply deviations to lands they own, but yet they're seeking deviations then that it's going to be unworkable when it applies to property of others. Section 34-202A requires a signed statement under oath that the applicant is the owner or authorized representative of the owner for all property that's subject to the rezoning and has the authority to secure the approval. They don't do that. They can't do that for deviations 3 and 4D. Mr. Witt and Mr. Patterson had an extensive presentation to you about that those deviations rely on vegetation, existing vegetation, on somebody else's property. Obviously, that's not allowed by the code. They can't impose deviations on other people, folks who were who bought into this 304-acre, 912-unit master plan development, who then bought their interest in that. They have property rights too, and their easements cannot be encroached upon in order for a rezoning and deviations to be granted to this developer. For those two reasons, the application is insufficient on its face and should be denied summarily. But now, moving on to the merits, I'd like to start off with addressing the governing Florida law on this. The statute, Chapter 163, very strictly prohibits any development order that's inconsistent with the comprehensive plan. There's no question that a rezoning is a development order. No one's asserting otherwise. It has to comply with the comprehensive plan. That applies to everything that's relevant in the comprehensive plan. And I know, Madam Hearing Examiner, you had asked one of the witnesses about policy 5.1.2. That and all other policies that are relevant to the issues generated by this application do have to comply with the comprehensive plan. Section 163-31941A, after a comprehensive plan has been adopted, all development orders shall be consistent with such plan. This comp plan was enacted in 1984. It's been amended, obviously, several times since, including, importantly, the community plan provisions. But the lengthy discussion or definition of what's a development order under Florida law clearly applies to all rezoning decisions. And I point out that Chapter 163-3215, subsection 3, that's the statutory cause of action for folks to challenge a development order that it violates, on the basis it violates a comprehensive plan, and it applies to development orders that materially alter the use, density, or intensity of a piece of land. Surely this applies here. This rezoning, if it were to be granted, materially alters the amount of development that could take place on this property. Right now, as we sit here, 912 units is the maximum. If the rezoning were to be granted, it would add 356 units to that overall total of the 304, and it would add that number of units to this applicant's share.
You're including the hotel in this?
Yes, I
Okay.
am. And now, for purposes of the comp plan, for purposes of the statute, we can get into hotels versus residential units in a moment, a little bit later, but all development orders, whether it's a single-family home, multifamily home, a hotel, commercial development, all development orders that materially increase either density or intensity or uses are subject to the act. So there should be no question whatsoever that this rezoning has to comply with everything in the comp plan that's relevant. They would increase the number of development units, and again, I'll use development units for both residential, permanent, and hotel units from 272 to 628, just on this 120 acres alone. That's a massive increase.
Well, what constitutes a material increase in this scenario that you're espousing?
I suppose if we were arguing about a 2-unit increase, a single-digit increase, we could debate and discuss whether that's material. I don't think, having read pretty much every development order case ever under this law, I don't think there can be any question that if you take the number of units from 272 and you increase that to 628, that there's any reasonable, plausible argument whatsoever that that's not a material increase in units. That to me would seem to be, unless your question is raising an issue I'm not getting, I'm sorry.
No, I'm wondering, what is your benchmark for that? Because we have multifamily timeshare and we have hotel, motel, right? And how are you treating those units? Are you treating hotel units equal to dwelling units in this scenario?
In here, on this location, and this case is of course all about this location, hotel and residential units have historically, always by multiple county actions, been treated as the same. So I refer to them as development units.
Well, I'm going to ask the applicant to clarify this during their rebuttal, because what I'm not clear on is what my understanding was of the history of South Seas and the units, that all the units were like separate lock-off units, right, with exterior hallways and everything. And my understanding is the request for hotel now is it's still a hotel, the other way is still a hotel, but this is a little different because it's internally accessed, and I'm focusing on what's the relative increase in impacts by virtue of that. So that's why I'm asking you what your perspective is on this. So is your perspective that my focus should not be on the delta of external impacts from what is approved today versus what they're asking for? Or am I looking at something else?
I think that as a general proposition, the delta is the question. You just look at general land use law in general. What's
External
allowed,
impacts. External impacts.
and when
Or impacts.
I would say yes to external impacts, but that's going to be light. It's going to be
Understood.
structures,
Understood.
traffic, people, noise, all that stuff.
Okay.
And I'll talk more about those. But any way you slice it, from our perspective, this is a big increase, a really big increase, given the finite amount of land involved, given the existing roadway network and the existing lay of the land in terms of the spliced nature of the buildings, some that this applicant owns, some that others own. It's very clear throughout the history of this project that it mattered that there was this very specific limit on the number of units. Call them residential, call them hotels. The record can allow no conclusion other than that was a huge component of this entire master plan development. And I'll come back to that in a moment. We think it's clear. But I haven't heard the applicant argue otherwise, that somehow this rezoning is not subject to the statutory prohibition or requirement that you must comply with a comprehensive plan. The judicial precedent is so strong in this area. The judicial precedent makes clear the law strictly prohibits an inconsistent development order. One of the top cases is out of this district, the 2nd District, Lee County versus Sunbelt Equities, Pinecrest Lakes, the Machado case, the Brevard County versus Snyder, the Supreme Court. I've cited all these to you in the letter that I handed out this morning, so I don't need to take your time and read you case law cites. The statute says, and the cases have always emphasized this, the statute says, and I'm quoting from 163.31944B, it is to be construed broadly to accomplish its stated purposes and objectives. So it's a remedial statute written to stop growth that was inconsistent with the environmental and the infrastructure and the community character and the other policy objectives of the statute. It was meant to stop that. So any doubt when it comes to applying this statute to this rezoning, any doubt that comes with applying this rezoning to the provisions of the code or the comp plan, because the law is to be construed broadly, must be resolved in favor of strict enforcement. The leading case is the Florida Supreme Court case, Snyder versus Brevard County in 1993, which, and I quote, "It is clear that orders on rezoning applications must be consistent with the comprehensive plan," very specific to rezoning applications. And Snyder said, "We hold that a landowner seeking to rezone property has the burden of proving that the proposal is consistent with the comp plan and complies with all other procedural requirements as well." And I'd spoken to that a little bit earlier this morning to you. And a point I want to make now, as I focus on rezonings, is that the animal of a rezoning is a very different animal than, for example, a special exception, where the law says if you meet all of the technical criteria for a special exception, you've demonstrated entitlement, you must be granted it. Snyder is the leading case, and other cases have made clear there is no entitlement to a rezoning. A rezoning request must be strictly construed for strict compliance with everything in the comprehensive plan, and it is within the discretion of the local government, indeed the responsibility of the local government, to deny it if that rezoning is inconsistent with anything in the comprehensive plan. The Lake Rosa case, 5 DCA 2005, rejected a claim that prior development orders can somehow vest you. It ruled every development order after a plan goes into effect must comply with the plan. Compliance with the plan, the Lake Rosa case said, is mandatory. City of Boynton Beach versus Carroll that I've cited in my letter is possibly the clearest on this idea of some sort of vested rights. A prior permit or zoning approval, ruled the Carroll case, does not create a vested right. It can be revoked where the zoning has changed. Now, of course, there's vested rights law, so if somebody vests rights, materially changes their position, spends a lot of money based on an approval, then changing the law on them later would violate their vested rights and they get what they had. That's clear. We surely don't debate that. And in fact, as I've said, this plan recognizes the vested rights, and so does CCA of this applicant. But there's nothing about, and the Carroll case makes clear, the law in effect at the time of the decision controls. So that's us, that's now. So this rezoning must comply with the code and the plan as it exists today. So you come back to the grandfathering. Any grandfathering that this applicant might have is limited to the 912 total combined development units, and that's it. Chapter 23 recognizes that by recognizing that South Seas Island Resort is part of the historic development pattern, and certainly by virtue of property rights law and vested rights law. They are vested to that. We don't dispute that, but that's all they're entitled to. Because, as I'll explain later, as you've seen throughout this hearing, I think for everything that matters to this comprehensive plan, there's no way this amount of development makes sense, can comply with this code and this comprehensive plan.
When you speak to vested rights as to the 912, is it your position that the existing development entitlements are no longer consistent with the LEED plan?
Yes, I think the testimony that you heard earlier from Mr. Gautier, for example, that sticks in my mind, was that, in his opinion, that if you were to apply everything in the code, everything in the plan today, that there's no way you would approve, I'm not speaking to you specifically, Your Honor, 912 units here. You've got to remember that when 912 units was approved in 1973, that was 11 years before the modern LEED plan was enacted, 12 years before the 1985 growth management law was enacted. We've come a long way since. I mean, the law that governs now is a completely different world than the law that governed in 1973. You didn't have a state law that required plans to protect life and limb and structures in the face of hurricanes and storm surge. We didn't know then, certainly not most of us in terms of anything reflected in Florida law or local comp plans, about rapid intensification of hurricanes, sea level rise, climate causing the water to get heated up and rise. We didn't have requirements for adequate infrastructure, strong environmental protections for coastal resources. All that stuff came in the 1985 law, and then it was reflected in the changes made, certainly by this comprehensive plan, and I forget when the LEED plan, might have been 89, there was some litigation, maybe is the early 90s, that the modern LEED plan that we're looking at with some tinkering today was finally amended to reflect all of those requirements in the new state law. So yeah, I think it's certainly from our perspective, it was hard to imagine how 912 units could have been approved on those 304 acres at the northern tip of Captiva, as far away from safety as you can get, surrounded by Pine Island Sound in the Gulf of Mexico, with rising seas, given the historic development pattern that's been out there, the narrow, constrained roadway, everything else that applies to this piece of earth. It's hard to imagine 912 would be deemed appropriate. It would be deemed, from our perspective, a lot too intense. And so, you know, from that perspective, the idea that we take 120 acres of that and we'd increase the number from 272 all the way up to 628 seems to us fairly absurd under this law, to be frank about it. And something that hasn't been discussed, but I think has to be considered when you talk about a rezoning and planning decisions, what happens to the rest of that 304 acres? Now, if this 120 acres is rezoned to allow this amount of an increase, how do you say no to the others that come in after that? The cumulative impact of this kind of density increase, this kind of development unit increase, given all of the testimony and evidence that you've heard and that I'm going to talk a little bit about today, it seems incomprehensible. If that's appropriate, I don't think you can possibly square that being appropriate, either on just 120 acres alone or the entire 304 acres if others want the same, and you're hearing they don't, but that changes. If that's appropriate, then what does this plan mean? If that's appropriate, then what does this code mean? If that's appropriate, what is this law all about that requires consistency with a comprehensive plan? So I think all the relevant provisions of a plan must apply. The statutory definition of consistent captures everything that you've heard, Your Honor. 163-31943A, a development order is consistent with a plan if the land uses, densities, or intensities, and other aspects of development permitted are compatible with and further the objectives, policies, land uses, and densities or intensities in the plan, and if it meets all other criteria. So, to dwell on that for just a few minutes, density and intensity covers everything. Whether one wants to call a hotel unit something different than residential, that means it's commercial and then it's intensity. If it's residential, and here it is, the testimony and record unequivocally shows that historically, for a lot of good reasons, here on Captiva, hotels have been completely equated to residential uses. But either way, however you slice it, it's either density or intensity, and it's inconsistent with the comprehensive plan because the density or intensity and the other aspects, the details of it, don't further the intent or terms of the comprehensive plan. And so, for example, you can't read that definition, I don't think, and accept the premise of the staff report here, where it says, well, the community plan provisions recognize South Keys Island Resort as its own thing, as a separate category from the rest of Captiva. And sure, obviously, Chapter 23 recognizes explicitly South Keys Island Resort as a component of Captiva, separate from the rest of it. But you can't read the statutory definition of consistent without saying this premise of the staff, a resort is a resort. So for purposes of Chapter 23, it was a resort then, it'll be a resort now. And the scale, the magnitude, the size, all the deviations, all the details of what that will mean don't matter. With all due respect, that theme, theory, premise of the staff report cannot withstand the statutory definition of consistent. Now, the other thing that you've seen from various ordinances that have come into play, Mr. Mintz's discussion, Mr. Gauthier, Mr. Murphy, is even if you want to look at South Keys Island Resort as somehow a separate part of Captiva from the rest of Captiva, but the history of the regulations, the ordinances, and what's developed out there is that they're about the same. The gross density at South Keys Island Resort, 3 units per acre for combined hotels and residential, is the gross density that's been the historic development pattern at the rest of Captiva. The heights, same thing, just about the same. So I think that maybe the applicant has tried to create some sort of scenario for you that South Keys Island Resort is categorically a different thing, categorically a more dense, more intense thing that somehow has been walled off from the rest of Captiva. But that's just not the reality of the record that I think anyone in this room has heard or created by the historical record of this rezoning application and the regulatory and development history of South Seas or the rest of Captiva. It was a resort, so it doesn't matter how big it grows, cannot withstand the plan. I'll talk about that in a minute here. The case law is also clear that the determination of consistency with the comprehensive plan looks at the plan as a whole. And that's essentially a question of, you look at the plan as a whole. In this case, that's community plan provisions for Captiva. It's everything about evacuation. It's the myriad compatibility requirements, environmental requirements, hurricane evacuation, coastal vulnerability, everything that applies here, environmental protections. And one asks oneself, does this comprehensive plan, looking at everything in total, not cherry picking any particular one, the entire thing, does this comprehensive plan contemplate that this amount of development would be approved here? And I cannot believe that there's any question that the answer to that is no, given everything that applies here. If this amount of development is allowed here, what does this comprehensive plan mean? Where would this comprehensive plan say no increase of development? Where else, the policies that you've heard people talk about, and I'll touch on a little bit more in reference to you, the policies about coastal high hazard area, environment, evacuation, storm surge, compatibility, historic development pattern. If that stuff doesn't apply here to stop an increase of development, where does it? What other parts of the county was that written for? They're written for here. And I think that that's fairly clear. There's no way the LEED plan contemplates this amount of development here. And as you're making that decision, what I would remind is that the burden of proof is on the applicant. That's the U.S. Sugar Corporation case, Village of Key Biscayne case, the Machado case. The applicant has the burden of demonstrating strict compliance, and that's another key aspect of this, the Brevard County versus Snyder, Machado versus Musgrove. That standard is strict scrutiny. So the applicant has the burden of demonstrating with evidence under strict scrutiny, and I refer to the definition of consistency, that everything about this rezoning, the density, the intensity, the use, the deviations of the master development plan, all aspects of that strictly comply with all criteria in the comprehensive plan. We don't think they've come close. We don't think they can come close to meeting that very exacting burden of proof here. I don't think, and if you think about what that burden of proof, has it been demonstrated to you that all the policies that apply here have been complied with? Again, I don't know that strict scrutiny, the Machado definition of strict scrutiny, arises from the necessity of strict compliance with the plan. A court makes a detailed examination for exact compliance with or adherence to a standard or norm. It's the antithesis of a deferential review. Strict implies rigid exactness or precision. A thing scrutinized has been subjected to minute investigation. Now, again, with all due respect, I don't believe that one can realistically look at the staff report or the presentation. I don't think one can look at the presentation made by the applicant here. When you look at everything, where was the environmental analysis of noise, of light, of water quality impacts to an already impaired water body? Where was the analysis of what additional nutrients would do to Pine Island Sound, an impaired water body designated by the state? Where was the analysis of the narrow, congested, vegetation-lined road that's one way out? Where was the analysis of real compatibility, other than arguing a resort is a resort? We've always been a resort, we're still being a resort. The only testimony and record, frankly, that we've seen that really looked rigidly and with exactness at the details of this were that put on by project opponents, people who live there, people who know this island. That the analysis those folks have presented it so far exceeds the analysis presented in support of the application. I don't think that it can be said at all that this applicant has met its burden under strict scrutiny of demonstrated compliance with the plan. Another aspect of strict scrutiny under Florida law, again under Schneider and every other case that's addressed this question, is that there is no deference to be given to a staff interpretation of the comprehensive plan. So that's, Madam Hearing Examiner, you read the plan, you read the code too, in terms of your reading of what it means, and you're not to give deference to the staff's interpretation that that's how we look at it, that's what we think it means. That doesn't matter. It's your reading of the plain terms and the intent of the plan that matters. And I want to make a point there. You've heard some reference to a Division of Administrative Hearings proceeding where a recent code change for Captiva was litigated, and where in general, again, that was a general, what does the code say on its face? This rezoning was not on the table there, as this applicant kept reminding us there, and it was a fairly debatable standard there. The challenger has to prove there's no fair debate. Challenger has to prove the ordinance on its face unquestionably violates the plan. The development order standard of review is completely turned around. It's completely different. The applicant, not the opponents, has the burden of proof. It's a strict scrutiny burden of proof, not a fairly debatable burden of proof. That's a major difference. And of course, the other major difference is now you have the details of a specific rezoning application that's on the table. And again, we think the applicant hasn't come close to demonstrating under strict scrutiny full compliance with the plan. Then I'll move to the code. The law's obviously same. A local government must deny a rezoning application that violates its code, the burden of proof. That's the Realty Associates. I'm not going to reference cases for you. They're in my letter unless you would like me to. Must deny a rezoning if it violates the code. The burden of proof, again, is on the applicant to demonstrate compliance with the code. An important aspect of that, and you've heard some, and you'll probably hear a little bit more difference between what the code might say and what the plan might say. The Buck Lake Alliance case, First District Court of Appeals, the year 2000, says, to be clear, an application can comply with the code, but that doesn't mean it complies with the plan. They are separate requirements, and compliance with the code does not, ipso facto, I think is the right phrase, demonstrate compliance with the plan too, because the code is inferior to a plan. The plan is the Constitution. The plan, where there's any difference or conflict, the plan prevails over any contrary provision of a code or a more lenient provision of the code. In fact, the lead plan says that, or a code section, 34-491 sub A of the code says that where there are apparent conflicts between and I'm paraphrasing, the plan and any regulations, the lead plan will prevail. So that's, I think, a pretty important thing to remember in this particular case. So that's the law. So I want to talk a little bit more about the merits of this application. There is a fundamental problem, a fundamental obstacle with this project, this rezoning. This is not a rezoning of a undeveloped piece of land or a partially built out piece of land. This is a rezoning of a parcel of land that is almost, I think the number might be 27 units, don't quote me, maybe something like that, remaining to be built out of the 912. A fully built out master development plan. That can't be forgotten. The idea of this master development plan, as it was enacted in 1973, as it's been confirmed multiple times since then, was that you give flexibility to the applicant to do integrated commercial, hotel, residential, with all the roads, all the open space. You come up, the value of a master development plan, as opposed to conventional zoning, is it allows you to look at an entire piece of earth as a whole and decide what makes sense to go where. And that's what happened here. And the code section 34-612 sub 2 sub H says the purpose and intent of a planned development district, and you've heard that the South Seas Island Resort MPD has always been treated as akin to a planned development because they didn't have that animal back in '73. It was kind of the model for what became that. So this is a planned development. The purpose and intent of a planned development district is to provide a process and record on which developers, public officials, the general public, and the consumers of development may rely. And that's what I'm talking about here. So an MPD is approved in 1973. That applicant gets the benefit of the flexible site design, gets 912 units approved, and now over the years, as you and I sit here, most of those have been sold off to other people who relied on that approval. And you know, I'll get into a little bit more of the detail. You've heard some of it, but requires specific amounts of open space, specific types of buffers and heights, and all of these things that when people bought, I'm buying into an already planned master development plan. This is what it's going to be. This is how dense it's going to be, and that mattered. This is how high it's going to be, and that mattered, and people bought into that. And people relied on that. That's the purpose of it. It gives the developer the go-ahead, okay, you can rely on this too. You can know that over the next, whatever, 40 years it's going to take you to build this. We're not going to change the rules on you. You get to rely on this by knowing you can make all your investments, build and sell off as many of those 912 units as you want. That's how it works. Everybody gets that surety. Everybody gets that reliance. And now here we stand after all that has happened over those 50 years. And all but 120 acres of those 304 have been sold off to other people. And you've heard from some of them. You're probably going to hear from a lot more of them today, tomorrow. And now this applicant, this applicant who comes in and does their due diligence with the county, and the county confirms to them before they purchase, yes, you are vested to that 912, and they bought the land. And now this rezoning, again, this is a different animal. Now this rezoning asks, okay, we want to take 120 acres that we still own, and we want you to start over from those, as though we can somehow physically extract that 120 acres from the rest of the 304, and we want a clean slate that allows us to increase from 272 to 600 something, I forget the numbers on another page, of what we want. That can't be what the PD provisions of the code contemplate here. And that's exacerbated, by the fact that, as you'll see and you've heard, when you drive through South Seas Island Resort, it's like the applicant owns this and somebody else owns that on the other side, and it's completely intertwined. The application here, acknowledges that this property, I'm quoting from the application, this property has functioned as a cohesive master planned resort since its inception. It is in the final phases of development. You've seen Mr. Murphy, he put into the record and explained that the 1973 master plan included, quote, enforceable conditions. I'm continuing to quote. Those enforceable conditions, to limit the overall density so as to create a very low density, high quality resort community. I continue, with an overall limitation to have the flexibility to develop pockets of higher density while leaving other areas completely untouched. Until now, I guess, where some of those open space areas, those untouched areas, are now going to be touched by new development. I continue to quote from the 1973, with a maximum limitation of 912 combined dwelling units and hotel units. So now, having received the benefit of that flexibility, the predecessor in interest to this applicant, received the full benefit of that. So much of that was sold off to other people. They get their benefit. This applicant comes in and buys it and says, now we want you to change the rules. Not by a unit, not by 2 units, not by some minor tweaks, but by a 40-some% increase of development overall. That isn't right. That is not what an MPD is all about. The spatial relationship here is so hugely important. You cannot physically remove this piece of land from the rest of those 304 acres, any more than you can physically remove it from the rest of Captiva, and I haven't really talked about that yet, outside of the gates of South Seas Island Resort. The presentations you've seen today, the stormwater, the drainage infrastructure, the garbage collection, the roads, the amenities, it is completely intertwined. I don't know how you possibly could say, that's you, we can make a decision here, as if the rest of those folks who own the rest of the 304 acres don't exist. This property is completely interspliced with the other ownership now. That's the animal of an MPD. It worked fine. It did what it was supposed to do. The idea that 50 years now, after all the profit's been received and everything's been developed, we get a lot more too, that can't be. That completely wipes out the integrity of the MPD, which violates Chapter 23 and everything else in the plan. There's no way we talk, and to make matters worse, it's not just the density, but we also want additional deviations from buffers. We want to encroach on the easements other people own. We want to create enough visitor traffic that other people are going to have people parking on their property. We're going to get more traffic, more noise, more community care. Again, if this was a raw piece of land that this developer wanted a big zoning increase over what was there before, and the new residents they're going to sell to will have to deal with whatever noise and traffic and other stuff that is generated by that development, well, then that's what they walked into, that's fine. But the idea that the folks who bought into that MPD, as it has been described very clearly and very carefully laid out, now they're going to get more noise, more traffic, more cars, more parking all over the place. That can't comply with the compatibility or the community plan provisions of this comprehensive plan. Their benefit, remember the code section about the government, the developer, and the citizens get to rely on MPDs. So the developer got the full benefit of what they did, sold off to this applicant. The folks who bought within that MPD, they don't get the full benefit of what they purchased, because now they get 356 additional development units full of people and all the impacts that come with that. That can't be right under the animal that is an MPD. That can't be right under the community plan provisions of the code, of the plan, and it can't be right under the compatibility and the traffic and all the other provisions of the plan. I'll move on to the provisions of the plan that talk about directly density. Captiva is so limited in its capacity to handle, accommodate new development. It has its own chapter in the comprehensive plan. That, you don't see that every day. And you can't read logically that chapter of the comprehensive plan in any way that other than it was meant to preclude density or intensity increases over what the historic development pattern was. The current limitations that exist for density, intensity, and height at South Seas are, and I don't think anybody can possibly claim otherwise, as set in ADD 2002-00098, which confirmed the same density and intensity authorized by the zoning resolution Z73-202. Again, as I've said before, that would not be approvable under the plan today, but it was then. And Chapter 23 recognizes that vested right by referencing South Seas Island Resort, but it sure does not allow an expansion of what was known to be South Seas Island Resort. So, you know, that 356 unit increase is just completely uncalled for, completely prohibited by Chapter 23 of the plan. Mr. Gauthier, Mr. Murphy made it clear to you that the existing number would never be approved let alone the existing number plus 356 units. The setting is important to that. The application and even the applicant's own witnesses acknowledge the vulnerability of this location. Ms. Crespo explained to you that this entire state of Florida, certainly at least South Florida, is grappling with the realities of hurricane intensity and storm surge. The mere fact that the application makes clear why are they rebuilding? Because they were devastated by Hurricane Ian, and that devastation was exacerbated by Milton and Helene later. When you've had people come talk to you about the hurricane vulnerability, evacuation issues, these are not hypothetical, they could happen one day scenarios. They are, it did happen. It happened 3 times in 2 years. Mr. Andrea, the landscape architect, referred to the new environment of frequent flooding here at Captiva. Structural engineer Mr. Wright, Christopher Wright, assumes storm intensity will get more intense over time. Certainly that's true. It doesn't sound like a location that makes sense for 356 units on top of the 272 that are there. And the plan and the code reflect these realities. That's all the provisions I'll cite to you in a little bit that reflect the extreme storm surge, flooding, hurricane vulnerability. You've heard about sea level rise too. In this very unique, very fragile, very vulnerable part of Barrier Island. And so the idea that we would gratuitously increase 356 units to the 912 already there in the face of that kind of vulnerability, it's irresponsible, just on one level, but it violates the code and the plan more directly for the purposes of why we are all here. Now, density is an important component in terms of some policies that address specific numbers, and it's obviously a key component of the historic development pattern provisions of the plan. The testimony you've heard, I think, makes clear that whatever density or intensity is appropriate here has to be at the very low end of the ranges that are allowed by the LEED plan. The plan and the code allow development only at the lowest density or intensity ranges. Policy 1.1.6 that applies to outlying suburban, it establishes a density range between 1 and 3 units per acre. Policy 2.2.2 of the plan says clearly maximum densities are not guaranteed. Plan development densities are determined on a case-by-case basis. So an argument, oh, we don't violate the 3 units per acre. No, we think they do. But even if they didn't, that's not an entitlement. The case-by-case basis for this particular piece of land, given the history, given the location, has got to be, as Mr. Gauthier, I think, testified, at the very lowest end of that range. Section 34-413 of the code. Again, and I want to be clear, whether one wants to call a hotel unit residential or commercial,
Well, the code calls it commercial.
What, I'm sorry?
The code calls it commercial.
Yes, ma'am. We acknowledge that. And the point we would add on to that is that when one is interpreting the Captiva community plan provisions, for them, hotels have always been considered, unlike the rest of the county, hotels have always been considered resident. Whether they were considered residential or commercial doesn't really matter. They've always clearly been subject to the 3 unit per acre residential density limit. So that's a key part of that. Obviously, we can't dispute the fact that on the mainland, most other parts of the county, hotels have never been subjected to the 3 units per acre residential limit. That's different here, given the historical development pattern at Captiva, given the string of ordinances that I think Mr. Mintz presented to you. And the county staff, I think, has been very clear about that as well, very, very candid about that. But either way, for other purposes of other provisions outside of the Captiva community plan provisions, However you slice it, this is too much development. Call it commercial or call it residential. 34-413, density or intensity of use permitted in any planned development shall be determined on a case-by-case basis in accordance with the range of density or the uses permitted or encouraged under the LEED plan at that location. And so again, I want to really focus the inquiry here. We're not talking about some outlying suburban parcel of land somewhere else. It's what's appropriate at this very specific location. Now, and I think the facts are clear that you have to be limited to the lowest density or intensity range here. At the very end of a narrow, environmentally sensitive barrier island, surrounded by already impaired Pine Island Sound sensitive waters, that close to Ding Darling Preserve, that close to a preserve owned by SCCF, that close to a preserve owned by the city of Sanibel, one of the more environmentally sensitive islands, barrier islands in the state of Florida, a special flood hazard zone, the coastal high hazard area, level A evacuation zone, one of the most hurricane and storm surge vulnerable areas in the state of Florida, connected to the mainland by one 2-lane, narrow, constrained road that has narrow shoulders for big stretches of it, vegetation, sidewalks, buildings you cannot physically move, with little room to clear any cars that break down during an evacuation. The causeway off the island was demolished and unusable after Hurricane Ian. The development pattern that has built up around it is low density, low rise, and that applies to both hotels and residential. Inadequate traffic, fire, and sewer availability. What's left under this comprehensive plan? Environmental, the only thing left that you could possibly say this doesn't have wrong is direct footprint environmental impact. And that's because it's already been built out under the 912 unit MPD. Every other matter, every other issue that matters under this comprehensive plan or this code is completely inconsistent with what this applicant is asking to be approved. The compatibility, the impacts on the surrounding land uses. I mean, you saw the presentation of Mr. Suarez, Mr. Mintz, the fellow who was here at the end of I think the last day that we broke, to show you, just really bring home the reality of how interconnected all of this is, and how you can't move without, if I'm another owner, I can't basically move without being confronted with something the South Seas Island Resort owns now, this applicant, and having that impact me, be it a restaurant, some other commercial use, a buffer that they want to use my easement, those kinds of things. The compatibility problem is just so stark. The land use and transportation experts made clear what the historic very low density and intensity development pattern was there. The traffic increase, the unsafe access, the congestion, the undue burden on the streets, the additional demands on an already unsafe evacuation time, the low-lying, flood-prone barrier island subject to extreme natural hazards. I mean, everything that this plan or code checks off in terms of a negative for development intensity exists here, again, other than a direct environmental footprint. But I'll talk about the environmental impacts still are really strong, really important in terms of off-site impacts, and of course, on land I own. I can't keep birds from flying in there. I can't keep wildlife from trying to cross the roads. The next thing I'm going to talk about is a prior ruling. It's in the document that I handed to you this morning. There was a zoning staff report for case number DCI2023-00058, and it references, I believe this might have been, Your Honor, a ruling of yours back in 2011, the HEX report in case DCI 2011-00048. This rezoning should be denied for the same reasons that the rezoning in that case was denied. In that case, the staff report, in the 2023 staff report,
What case
recommended...
was it? What case was it?
It was, I have a name, and I'm not remembering the name.
I wasn't the hearing examiner
It was
then.
Laura Bellflower, as I recall.
Yeah, I wasn't a hearing examiner then yet, but I'm curious as to what case it was.
Yes, ma'am. Mr. Mendez, help me out there, the Kinsey Inn project. That was the staff recommendation, Mr. Mendez? The staff recommendation in 2023 was the Kinsey, or the 2011 hearing examiner was the Kinsey?
Yeah, and it's my understanding it never went to the board and was withdrawn, so it's not binding.
Okay. The real focus is on the 2011 hearing examiner report. It made 3 or 4 findings that I think are really relevant here. The first was that the ruling in that case was that the exemption in Chapter 34 of the code, the exemption for hotels from the residential density limits is not supported by the Lee plan, said that report. The plan does not specifically authorize different treatment between hotels and residential in terms of density, was the ruling in that case, whether it's a planned district or a conventional district. And I think apropos of a comment that you had made a moment ago, even, and I'm paraphrasing the rulings in that hearing examiner order, while designated commercial.
I am going to interpose an objection.
I'm
The hearing
talking.
examiner does not make a ruling in that situation. It makes a recommendation, and the recommendation never went to the board. So, and even in your own letter, you said that zonings are determined on a case-by-case basis.
That's fine.
Noted, continue.
Thank you. Even while, again, if I may continue, while designated commercial, hotels are still subject to the residential density standard, was the interpretation of the plan in that case. Now, the recent staff report from 2023 points out that the plan has not been amended since that 2011 hearing examiner recommendation or report. And so that same interpretation should apply here. Under policy 1.1.6, hotels and residential are to be equated under that theory in terms of residential density. But again, I come back to points I made earlier. That does not mean that on this location they're entitled to 3. It means they need to be at the lowest end of that density spectrum. And in the context of an integrated plan development, it doesn't make sense otherwise. That's a hotel, that's a residential. The idea that in this location, specifically for this master plan development project, that those units, I'd call one a hotel, it doesn't count. The other, that's a residence, it counts. It doesn't make sense given the lay of the land and existing buildings and the spatial relationships here. The next point in that ruling, that 2011 ruling, is that the approval of old pre-plan, pre-code structures is not precedent for approving them again under the new code, under the new plan. And that addresses, in this case, there's been references to, I think, 4 old historic inns on Captiva, and the applicant has pointed to them and said, oh, well, they were technically higher than 3 units an acre. So our application is appropriate too. But those are non-conforming pre-code, pre-plan. They don't support this current application. The final point from that 2011 ruling and recommendation that I want to make was about deviations, Your Honor. And the ruling there was that if a project can comply with the code by reducing density or intensity, then the deviation is unwarranted and has to be denied. And that's what we have here, right? The deviation requests are being made so that they can try to fit more development on the site than it can handle. That's just, I don't think there's any other way to look at it. They don't need all of those deviations if they have less density and intensity. The deviations are not warranted here. So let me talk specifically next about the Captiva Community Plan limitations. Separate and apart from the density and intensity plan and code provisions I've spoken to, separate and apart from the plan and code provisions about compatibility that I'll speak with in a little bit, this rezoning violates the Captiva Community Plan limits, okay? The goal 23, the goal of the Captiva Community Plan to enforce development standards that maintain the historic low-density residential development pattern of Captiva. And I'll talk in a minute about the support document that underlies the adoption of these provisions into the plan, but where Goal 23 talks about the historic low-density residential development of Captiva, and I believe these were put into the plan in 2018, it's talking about hotels and residences being equated to residential density, because that's how it always was done there. That was the historic development pattern at Captiva. Enforce development standards that maintain that low-density residential development pattern. Objective 23.2, continue the long-term protection, long-term, not just until somebody comes along in 2025 and wants to change it, the long-term protection and enhancement of existing land use patterns, meaning those that existed when this was adopted into the comp plan, not existing as some sort of future, will move in the future thing. Unique neighborhood-style commercial activities and infrastructure capacity, and then policy 23.2.4, limit development to that which is in keeping with the historic development pattern on Captiva. A couple of lines down, it reads, the historic development pattern on Captiva is comprised of low-density residential dwelling units. Again, when this was put into the plan, hotels were subject to residential density limits. Minor commercial development and South Seas Island Resort. Okay. The staff recommendation in the application cannot withstand the plain terms of Chapter 23, its objective and its policies. It uses very strong, very clear words and phrases. Maintain the historic low-density residential development pattern, continue existing land use patterns, limit development to that which is in keeping with historic development pattern. Maintain, limit, continue, cannot possibly read to mean expand or increase. You look at the dictionary definition. Maintain means to keep in an existing state. Limit means something that bounds, restrains, or confines. A maximum, a prescribed maximum amount, quantity, or number continues that definition. The word continue means to remain in existence. These policies, this goal, this objective cannot be read to allow an expansion, an increase in the historic development pattern. And historic development pattern is both density, intensity, and its height as well. And intensity measures are traffic, environmental impacts, infrastructure impacts, everything that's generated by this request for increased development here. So again, the premise, South Seas Island Resort, is specified in the chapter. It's a resort, end of discussion. It doesn't matter how much bigger it gets. That can't be true, given the language used in the Lee County Comprehensive Plan chapter that was specifically written to maintain what was there: low density, low intensity, low rise. The plain terms and the clear intent of that chapter absolutely preclude treating South Seas Island Resort as some sort of open-ended land use that then there's no limit on how much development can happen. And I think, you know, this notion that we're going to change the rules, and as much as they can fit with setbacks, deviated setbacks, of course, and buffers and that kind of thing, that's definitely not what Chapter 23 was about. That was not the historic limit. The historic limit was always 912 combined hotel and residential units. The historic limit was always heights no less than 45 feet above grade. What's being asked for here blows apart the historic development pattern at South Seas Island Resort and Captiva. That historic development pattern established by the 73 zoning, reiterated, reconfirmed by the 2002 administrative interpretation, repeated at every possible option for some sort of county action, like the lock-off compliance agreement that you heard about. This is an unusual case. I mean, not that what I know completely matters all that much, but I have never seen a situation like this where the historic development pattern was so clearly, purposefully, intentionally documented throughout the course of that development. And of course, then you've also seen through Mr. Mintz, I think, the pattern of ordinances that followed that precision of time that also limited the rest of Captiva, 3 units an acre for hotels and residences, height limits that are like the same. There were some minor tweaks in terms of heights for South Seas Island Resort. And I think the staff report acknowledged, at least tacitly, acknowledges that the ADD limits are the historic development pattern here. The staff report compares the rezoning. You'll see there's a section, compares the rezoning, density, intensity, heights, et cetera, to that established in the ADD. Given the role of density, intensity, setbacks, compatibility, all of those things throughout the LEED plan, throughout Florida planning law, this notion that a resort is a resort, doesn't matter how much bigger it gets, cannot be consistent with the law, cannot be consistent with the code or the plan. I think Mr. Gautier articulated that very well to you in his presentation. Scale, magnitude, density, intensity, heights, they're a prime component of a historic development pattern. So is the amount of traffic generated, the amount of noise, the amount of light that comes from density and intensity. The extensive public record in terms of ordinances, county actions on South Seas Island Resort is unequivocal that the historic development pattern on that 304-acre South Seas Island Resort has never been more than 912 units. Every action has meticulously confirmed that and not allowed that to be increased. Never. Now, and when we had a brief discussion, I'm going to acknowledge Ms. Montgomery's standing objection, but the 2 things I put into the record in terms of transcripts for you from a corresponding administrative hearing, zoning manager Mr. Rodriguez has said, and I don't think the county doesn't dispute this, the ADD identifies the historic development pattern of South Seas. Planning manager Mr. Dunn, Brandon Dunn, confirmed the ADD in the 73 zoning resolution limits South Seas to a combined hotel residential unit cap of 912 units. And to address this applicant's argument, well, we could have amended that. They didn't. There was never an amendment, Mr. Dunn confirms, to the ADD. So some speculation that possibly we could have amended the ADD to increase the development. Maybe if we did that before it was all built out, that's fine, but it never happened. It's never been the historic development pattern here.
Madam Hearing Examiner, I'm going to propose an objection and ask the
I
question.
recognize the exemption, and I'd prefer not to be interrupted, quite frankly.
I'm allowed to raise objections, Mr. Grosso, under the Administrative Code 2-6. He referenced a portion of Brandon Dunn's testimony, but if you take that out of context, that is not what Mr. Dunn testified to. So if you're going to allow it in, then I would submit you have to allow all of Mr. Dunn's testimony in, so it's clear what Mr. Dunn actually said. Or if you're going to, as earlier, take it in the context of not necessarily evident, allowed cross-examination, because Mr. Dunn's not here for either of us to cross-examine to clarify that point.
The
Okay, thank you.
portions of the
See-
transcript I put in can be read, and they say what they say. If counsel wants to put in other portions during rebuttal, obviously, as you've made clear, they get to do that. The other thing, the support document for the community plan provisions, when they were put into the LEED plan as a reference, where it's describing the historic development pattern. And it refers to South Seas Island Resort. This is the support document for the CPA amendments. I'll identify them for you in a moment. But it refers to South Seas Island Resort as, and I quote, a blend of hotel, commercial, and residential uses delineated in a separate 2002 administrative interpretation. The staff report here, again, compares what was allowed in the ADD to what's being requested here. And the staff report at page 2 says, notwithstanding that the ADD was not a development order, previous property owners have developed in accordance with the guidance provided in the ADD. This staff report for this rezoning acknowledges at page 5, although the ADD is not a development permit and did not authorize development, it is an appropriate starting point for reviewing the proposed rezoning application. There cannot be any plausible claim that the historic development pattern at SSIR is as limited and circumscribed in terms of hotel and residential density and heights in the ADD. This rezoning, and I'll move to the master development plan part of it, this rezoning would change the ADD's development standards. Development standards, the phrase used in the community plan provisions of the plan. The ADD sets forth, I'm quoting, development standards, I'm quoting from the ADD, development standards applicable to South Seas, based on standards that have been applied since its inception in 1973. And those include the residential, the hotel unit limits, and the building height limits. Page 2 of this staff report for this rezoning references that the ADD, I'm quoting now, includes reference to open space, landscaping, building setbacks, building height, traffic impact, parking, and other development standards. This MPD would change those standards, make them more flexible, more lenient for this applicant in the face of a significant increase in density. It violates the community plan provisions of the plan. The rezoning would replace the ADD standards with those that are less stringent, coupled with a massive increase in development. How does that possibly work? Those standards were there to protect everybody who bought within that land from the impacts. Now there will be, again, only looking at this 120 acres, 356 units worth of more impacts, but yet reduced development standards and deviations from things that can't be consistent with Chapter 23 or the compatibility or the requirements in this comprehensive plan. The rezoning would not continue the existing land use pattern. It would not limit development to that which is in keeping with the historic development pattern as required by Chapter 23 of the plan. You know, the applicant has suggested to you that there was something somehow inappropriate about the ADD. The applicant has suggested it might have been like procedurally infirm or substantively didn't make sense. I think a phrase they used in the application was it inappropriately blended hotel and residential density. Well, the applicant might not like that, but first of all, it's kind of irrelevant. I mean, it was codified later in into the code. It was codified in the code. If South Seas is going to be exempt from everything else, it has to comply with the ADD. And so, now that recently got taken out of the code, but the historic development pattern was the ADD was the standards, or the code was the standards, and they both limited development there to 3 gross units, hotel and residential per acre, and the 45 maximum height limit. So it was in the code. They can argue all they want. They didn't like it, and it was somehow inappropriate, but it was put into the code by a duly adopted ordinance. Mr. Murphy, who wrote the thing, explained to you that this applicant's predecessor in title was involved with him every step of the way as he investigated, did the field work for that ADD to see exactly what was on the ground. They were with him. They agreed. They assented to it. They were directly involved and confirmed its accuracy. Now today, the successor in title is somehow suggesting there's something inappropriate about it. The county's actions have acknowledged since its inception that it is the governing document for height and density, intensity at South Seas Island Resort. The ADD and the code, up until a change in 2023, were exactly the same in terms of density, hotel and residential. So, that's that. The next thing that the applicant has suggested to you, I think, was some sort of speculation that, oh, well, in the 60s, maybe we could have done a lot more. So you should perhaps compare what's being requested now to the thousands of units that they speculate they might have been able to get approved for in the 1960s. That can't matter. Fact of the matter is, that's speculation. Fact of the matter is, that never happened. It was not the historic development pattern. Fact of the matter is, in 1973, the predecessor to this applicant determined what's in our best interest is to do a 912-unit integrated master development plan for the site design flexibility to make it a great world-class low-intensity resort. That's the reality of what's been on the ground in terms of community plan, in terms of compatibility, and everything else. Some speculation, what we could have done before there were modern zoning laws has nothing to do with this case. The other thing that, and I touched on it briefly, but the applicant points to these 3 old historic hotels or motels on Captiva outside of the gates of South Seas Island Resort. The Twin Waters Inn is one, Jensen's Twin Palm is another, Captiva Island Inn is another. Twin Waters was approved in 1931, historic designation by the county. Jensen's Twin Palm approved 1932, historic designation by the county. Captiva Island Inn approved 1950, historic designation by the county. Jensen's on the Gulf was approved in 1976. I don't think it's an historic designation, but it's well before the 82 code in the modern plan. There's no reasonable interpretation, and I think I might be getting to a break point here. I can read.
I'm checking on her, usually an hour and a half.
I can read the room.
She needs a rest,
So let me finish with this
Yeah.
for a pause.
and then we'll come back to you.
Thank you. There is no reasonable interpretation other than the historic development pattern at both Captiva and Seas Island Resort has been maximum 3 units per acre, gross acre, for hotels and residential units. I will take a pause now. Thank you very much.
Okay, thank you. We're going to take a 10-minute break, and we will resume at 10:38.
Thank you. So to continue on about the scale and the intensity here, I want to be clear that what the rezoning request is not, in terms of uses, categorically different than what's always been there. It's a question of scale. The difference between what's approved and was on the ground pursuant to the 73 rezoning and ADD, the difference is as follows. There were 140 employee units that would now be converted to 193 multifamily condos. There were 107 hotel units that, if this rezoning were to be approved, would now become 435 hotel units. And there would be hotels both on the north side of the property holdings they have and on the south side of the property holdings they have for the first time ever. Mr. Murphy and Mr. Gauthier, community leaders Mintz and Suarez, explained to you in great detail the huge density or intensity increase that would follow, of a magnitude that's never been seen on Captiva and at South Tees before. That's the problem. Completely out of scale with the existing uses, a great departure from the historic density or intensity allowances. Again, whatever number you can fit, given our bulk and height and other restrictions, is never been the historic development pattern out there. Mr. Mendez has made clear to us that the rezoning would allow, I quote, a net increase in intensity. To drill down a little bit deeper, Mr. Murphy, pointed out to you, and the documents are clear about this, the 5 acres of commercial development that were approved in the 1973 rezoning, confirmed in the ADD, were meant to serve the ancillary purposes of the guests and the residents of those 912 units. And they were never for hotel commercial development. That was not what they were there for. That was not the historic development pattern here. But now we would change that. There'd be a hotel there. And the rezoning would create adverse impacts on the south part of the resort by putting a hotel that never existed there. So those owners at that south part of the resort never had a hotel next to them. They would now. Great departure from the historic development pattern here that never existed, okay? Now, so if you're one of the residents who lives there, and those 5 acres were there to meet your ancillary commercial needs, now you won't have that anymore. Now you'll have 356 more hotel units worth of people competing for your light, your space, your parking, all of those things, and you no longer have that. So we replace what was a service, an amenity for you, with 356 units worth of hotel guests. That's not a good trade-off. That's not the benefit of the bargain they got with that MPD. That's not compatible with their uses. Regarding heights, the CCA, to be clear, has no objection. It makes sense to change the building standards here so that people have to elevate above the minimum federal flood elevation standards. That's sustainability. That's necessary given the sea level rise and other impacts that are coming to Captiva that are already here. Sure. And so the idea that to avoid the regulatory squeeze will change where you start counting your height. That's fine. That makes sense. It's appropriate. It's sustainability. But what's being done here is, under this false flag of resiliency is, oh, while we're at it, then let's not just change your starting point, but now you go higher than you used to be able to go from your starting point. That's the problem. Mr. Murphy and Mr. Gauthier testified that the documentation is clear, has always been low-rise building heights on Captiva and at South Seas. There are major components of the development pattern. They're a key to the ambiance, the feel, the character, the unique nature of the island and South Seas Island Resort. The applicant has not demonstrated that the heights of the demolished buildings were anything near what they're asking for in this application. There's no evidence that heights 45 feet above the lowest habitable floor are required to build under the new FEMA standards whatsoever. It's gratuitous height increase. None of the buildings demolished were 3 habitable floors over parking. That's what the evidence has shown. The South Seas Island Resort Historical Development pattern has always been limited to the lesser of 35 feet above grade or 42 feet above sea level. This would be a major increase to that. No structures exist on Captiva today as tall as the proposed building heights here of 3 stories above parking and 45 feet above the lowest minimum habitable floor. But that's what the rezoning is asking for approval of. It would allow structures that are 20 feet taller than anything that's ever existed there before, 20 feet taller. And when the heights we're talking about are 45 in that range, 43, 20 feet's a huge increase. It's not the historical development pattern here. Mr. Mintz and the building height ordinances he put into the record show that no building on Captiva, including South Seas, could have been taller than 45 feet above grade. No existing building, even if rebuilt to the new FEMA elevations, could possibly reach 65 feet as being requested here. This rezoning is not about resiliency. It's not about preventing a problem for South Seas that when it builds back, it's going to have to meet new FEMA flood elevations and thereby lose the amount of space in its units. That's not what this is doing. This is going way, way, way beyond that. The reality of the height increases was made clear by the Captiva Fire Chief Paul in the Captiva Island Fire Control District letter that he read into the record, where he says, he acknowledges we're still trying to work with them, but he tells you that the fire district will be adversely impacted due to the proposed changes in building heights. The district does not have the ground ladders or fire flows to provide a sufficient response to the upper floors of these new buildings, and that an increase in units due to the approval of the rezoning may also result in the need for the fire district to increase staffing. The letter goes on to say the intensity of hotel space and timeshares creates a larger life safety and property risk for the visitors to the resort. And he concludes, in addition to the building being lost if a fire occurs due to the inability to suppress fire on upper floors, lives may also be lost. Now, that's evidence that the building heights were never here. This blows away the historic building heights. It demonstrates the problems with intensifying development at this vulnerable island. Lives may be lost, and we'll talk about that when it comes to evacuation as well. Again, everything from aesthetics, community character, to public safety is strongly and negatively impacted by this application. The next thing I want to talk about, I've referenced it before, but the community plan provisions, and this is in the record, the community plan provisions were enacted into the comp plan in 2018. And the support document explained a lot about what Captiva is, its historic development pattern, its setting, and that data and analysis is really important to a lot of issues in this case, not just the compatibility with the community plan provisions. That chapter was adopted into the plan in 2018 by Comp Plan Amendment 2015-0009 by Ordinance 1804. And now this is unusual. This is an unusual part of this adoption ordinance. This doesn't usually happen for comp plan amendments. But that adoption ordinance said specifically, and I quote, "The corresponding staff reports and data and analysis, along with all attachments and application submittals for this amendment, are adopted as support documentation for the Lee plan." And again, the general requirement in Florida law is that data and analysis is not adopted. It's just there as supporting document. So the fact that this ordinance says that, I think, gives it a lot of extra weight in terms of its importance to interpreting and applying the Lee plan, and in particular the Captiva community plan provisions. And what it says is really important. There are some very key passages in that document. and I'll reference just a few of them. It's referencing, back then in 2018, the policies that are now in Chapter 23 were in Chapter 13. So it references chapters in Policy 13, but the numbering has been changed. And the text of the objectives and the policies are the same. And it says, of course, we're introducing policies to limit development to that which is in keeping with the historic development pattern. And it explains what Chapter 23 currently says today. And it says that this continuation of a prior policy to preserve historic development pattern is to preserve historic structures and the historic development pattern and compatible redevelopment. Compatible redevelopment. It goes on to say that the provision adopted into the plan, historic development pattern provision, will acknowledge the unique development known as South Seas Island Resort. And I've already mentioned this to you, which is a blend, it says, of hotel, commercial, and residential uses delineated in that ADD. The objective to be put into the plan, this data says, protects the existing neighborhood form and densities. And it goes on to say Captiva's land use pattern is guided by its location in a coastal high hazard area. Public safety and evacuation are a concern. The island's only evacuation route is a constrained roadway. It says, consistent with policies I won't read to you that limit development where hazards exist, density on Captiva is 3 units an acre. Again, back then, up until recently, density applied to residential and to hotels. Heights are also limited, this document says, in keeping with Captiva's, I quote, low-rise buildings. That support document goes on to say that the goal of the Captiva Community Plan, the historic development standards, is the intent of which, it says, is to address both the environmental and land use and development issues vital to the protection of a fragile barrier island. This goal serves as a description of Captiva as it has historically developed and exists today, a pattern of land use and low-impact development within the island's long-time context of environmental protection that should be maintained and supported into the future, it reads, unquote. The document goes on to say, I'm quoting still, 2 overall issues underlie a number of the policies under this objective. First, Captiva as a designated coastal high hazard area. And the document explains specifically cited as issues of concern for coastal high hazard areas are evacuation times, building structural requirements, density increases, and infrastructure capacity. These reflect a recognition of additional risk to life and property present in coastal high hazard areas sufficient to warrant, again, I'm still quoting, more stringent regulations for safety while protecting property rights. Madam Hearing Officer, that's what Chapter 23 is about. More stringent regulations, not the same as those on the mainland. The document continues that it is intended to bring about risk reduction. It says risk reduction, I'm quoting, is typically accomplished, particularly in the Lee Plan, by limiting rezoning approvals to those which do not increase density. Again, when this was written, up until a code change last year, density applied to both hotels and residential units. It continues, and I'm quoting, avoiding replacement of current residential structures with much larger structures able to house considerably more people, which is inconsistent with the goal of putting fewer people at risk to storms and coastal hazards. It goes on to read, efforts to control density are important because, and I quote, the island is in Zone A, evacuation Zone A, with the longest evacuation time to shelter in the county. It goes on to say it's 29 miles from the South Seas Gatehouse to the nearest shelter. Evacuation times, the document reads, are further complicated since any evacuation must use a single route and a single exit point off the island. The Sanibel Causeway, it says, through the limited road system of Sanibel, which must also accommodate the evacuation of Sanibel residents and visitors. At the same time, Captiva, it says, is most impacted by any tropical storm event. Again, residents and visitors, Your Honor. The document goes on to say that this evacuation route off the island is a constrained roadway leading to another island with a limited road system, eventually leading to a single two-lane causeway to the mainland and eventually to higher ground. I'm no longer quoting when I say to you, you've heard that that causeway was wiped out by Hurricane Ian. The document continues to read, there are wind speed issues for the highest causeway bridge that could force it to close to traffic once a trigger wind speed is reached, as well as low-lying causeway islands susceptible to overwash. The document continues to read, any traffic incident interrupts the flow of traffic and will slow the overall evacuation. And on narrow roadways with minimal shoulder area, one vehicle breaking down could slow down the entire evacuation process for hours. It goes on to explain, I'm quoting, the right-of-way of Captiva Drive never exceeds 50 and narrows to 25 feet in certain portions. It says the maximum shoulder width, which is not consistent, barely meets the 2-foot standard for a rural highway with the lowest traffic count. It says any vehicular breakdown has very little room to be moved to the shoulder in order to clear any resulting traffic backup. The very limited clear zone, et cetera, is combined with the heavy vegetation planted along the adjacent private property, makes moving a disabled vehicle off the roadway more difficult, with consequent traffic tie-ups slower to clear. This problem worsens in the case of an evacuation, it says, when drivers may not always be at their best or most calm. And the document states that reasonable limits on the number of residents and visitors who need to evacuate from the island is vital for public safety. It concludes, this warrants, I'm quoting, steps to control the density and intensity of use for island properties to that which currently exists. So the face of the community plan provisions, the support document specifically adopted to help interpret the plan, including those provisions, makes clear that they were put into the plan to maintain the levels of hotel and residential density that was there, not to allow a rezoning that would increase or expand that. It also makes clear, I think, as you're weighing and balancing the testimony, for example, of competing coastal hazard experts or competing evacuation time experts, which to give the most credibility and weight to. We're not talking about some theoretical evacuation zone somewhere. We're talking about this very constrained, and you've heard the words I've read, evacuation zone. There's no question this rezoning violates the chapter goal, objective, and policy of the community plan provisions. Now, I want to move on to compatibility separate and apart, and I really want to make a point of emphasis about this. The community plan provisions, Captiva community plan provisions, require the denial if there's rezoning. If they did not exist, the compatibility requirements in the code require the denial of this rezoning. These are completely separate, independent sets of requirements. If one didn't exist, the other would preclude the rezoning. I want to be really clear about that. So the compatibility problem, the magnitude, the density, the intensity, the heights, the numerous deviations are adverse to the surrounding uses. The community character, the quality of life, their living environment, and you've seen just how intertwined all this ownership is. Garbage, stormwater, amenities, everything, buffers, physical encroachment on other people's easements. The complementary commercial services being replaced by 356 new hotel rooms full of guests instead. Traffic, car, bike, pedestrian, golf cart conflicts. I think it was Mr. Rourke who explained that. That's a quality of everyday life kind of thing. If I'm trying to walk around there and I got more bikes, more cars, more golf carts, those are basic livability, compatibility problems that I don't know that the applicant and the staff even gave much to you about that, but you've heard so much overwhelming testimony about how adverse all of those aspects of this development would be for those existing neighbors. And so there are a lot of things violated here by this rezoning. Policy 2.2.1, rezoning proposals shall be evaluated as to compatibility with surrounding land uses. That's violated. Policy 5.1.5, protect existing and future residential areas from encroachment of uses that are potentially destructive to the character and integrity of the residential environment. If such uses are proposed in a planned development, I'll skip over a bunch of words, or where no adequate conditions can be devised, the application will be denied altogether. That's policy 5.1.5. Again, this idea that a resort is a resort can only make sense if policy 5.1.5 doesn't exist. A resort as a resort does not look at character, integrity, the residential environment. It can't be reconciled. And the testimony has made clear this is a matter of too much stuff in too small of an area, and too small of an area that's already been fully built out. And so conditions just simply can't cut it. More buffers, more vegetation, lighting requirements, whatever the case may be, this is too much stuff to fit on too small of a piece of land already built out where people are making their lives there. There's no conditions that can make this approvable. It's too much. Policy 5.2.2, when rezoning is required, that's this case, prevent and mitigate adverse impacts to the surrounding areas. Goal 6, allow commercial development only if well planned and only at appropriate locations. So if we're going to call the hotels now commercial development instead of residential the way they've always been treated, it violates policy 5.2.2 because it's not well planned, it's not in an appropriate location given its geography. Well planned was the MPD in 1973. This would disrupt that well planned master development plan. Violates that goal too. Policy 6.1.1 sub 5, all applications for commercial development will be evaluated as to the impact on adjacent land uses in surrounding neighborhoods. Policy 6.1.4 allows commercial development only when compatible with adjacent existing and proposed land uses. And 3 code sections I'll point out, section 34.612.2D, the purpose and intent of planned development districts is to avoid, not allow and condition, but avoid negative impacts on surrounding land use. Section 34-145, D4A1C, and all of these, Your Honor, are in my letter. It precludes rezoning that is not compatible with existing and planned uses in the surrounding area. Section 34.413 limits both density and intensity of use in a planned development based on the range of density or uses permitted or encouraged under the LEED plan at that location and the nature of and the density and intensity of existing development surrounding the property. I just don't think there's any way that one can conclude from hearing all of what we've heard in this proceeding that those policies are complied with, certainly not at this location, not at this density. That's compatibility. I want to move to hurricane evacuation now. You know, you have seen in this proceeding coastal maps out of the county's plan that I've just read to you, excerpts from the Captiva Community Plan support document. You've seen vulnerability studies, erosion control district study. I think there was an APTIM study, perhaps. The application, the staff report, Mr. Alexander, Murphy, and Gautier, all agree this is an extremely hurricane and storm surge vulnerable barrier island. And remember, why do we call them barrier islands? They're there to take the hit to prevent the mainland from being devastated by hurricanes. They're the barrier. They're not the area we should be building up and tearing down in terms of more vegetation, more open space being converted to concrete. This island bears every possible official designation of vulnerability you can get under this comp plan or under state law. Coastal high hazard area, evacuation zone A, flood zone, et cetera. There's nothing you could apply to the most vulnerable places that doesn't apply here. The applicant has, from our perspective, with all due respect, tried to downplay the vulnerability of this barrier island. It's a barrier island to a barrier island. And I think their efforts, frankly, lack weight, lack credibility. I mean, certainly hurricanes Ian, Helene, and Milton demonstrate that. The evidence, the testimony has certainly not been that we're fixing to enter a phase of reduced hurricane activity and reduced hurricane intensity. The clear evidence is to the opposite. It's getting worse. They may not be getting more frequent, but they're getting more intense. So you're talking, you're talking about a huge increase of development density, putting people, 356 more units of people at risk in an extremely vulnerable area. There's no way that can comply with this comprehensive plan. And it's both the coastal hazards, the storm surge, it's everyday flooding. Mr. Alexander testified to you about, sure, these are going to be built under modern structural requirements. Obviously, they're better than they used to be, but they're not going to be built high enough to avoid all the storm surge that will come. There's still going to be impacts. And if this applicant were exercising their vested rights and rebuilding devastated structures, those would have to comply with the new modern building heights. So if there's been some sort of suggestion here that in order for us to make the rebuilding more resilient, you've got to give us more density too, that just doesn't make sense. Any replacement buildings, we're going to have to meet modern public safety flood requirements. So adding 356 units to that is not about resiliency. It's not about protecting the people who live there. It's about more development on the site. There's two components of this under the LEED plan. There's the increased hazard exposure, that's storm surge, that's sea level rise, that's coastal flooding, which is unassociated with hurricanes. And then there's evacuation impacts. Those are separate impacts addressed, both of which require denial under the LEED plan. And you've heard the testimony of Sanibel officials. You heard the testimony of Mr. Alexander. I don't think you can get farther away from safety than the northern tip of Captiva, where South Seas Island Resort is. Narrow, constrained, two-lane road, one way off, that's it. The Sanibel folks who testified credibly revealed the challenges, the difficulty, again, not of some evacuation route somewhere, but this particular one that is impacted by this. And I recall Mr. Mendez's own aerials when he was showing us some aerial photographs. I mean, you could see how narrow, how constrained this roadway is. I think you'll see that when you do your site visit, that this is not an evacuation route that safely is calling for there to be 356 additional units worth of people to evacuate. And Mr. Alexander made it very, very clear to you, and the community plan support document made clear to you, evacuation is indeed about hotel guests too. You cannot assume, despite the obviously good aspirations to try to get people out earlier, to try to dissuade them from coming down, you cannot always assume that that good fortune that we had in Ian and other hurricanes is going to prevail into the future that includes more intense hurricanes, and as Mr. Alexander explained to you, more rapidly intensifying hurricanes. But what he was explaining was that if there's nasty weather coming, emergency managers aren't evacuating people. And when that nasty weather very quickly, unexpectedly becomes a hurricane that now requires evacuation, that's the problem. And so if you've been counting on, we were able to get them off early in past decades, we'll always be able to get them off early. If you're counting on that, you're running a huge risk that lives could be lost. Mr. Alexander already told you that given the geography and the lay of the land here, the current evacuation time is unsafe, in his opinion. His evaluation, we would say,
was much more of a realistic evaluation of this particular evacuation route, this particular island, these particular hazards. Not some sort of theoretical, let me run the numbers based on, you know, the best case scenario, and let me conclude that I think those numbers will be fine. We always got people off before, we'll get them off again. I think that's the difference between the competing evacuation presentations that you've seen. I think one's much more grounded in realism about the nature of this area that's been devastated and people are still rebuilding from Ian and the other two storms, versus one that's designed to, let's give the benefit of the doubt to assuming we can get hotel guests off early. Let's give the benefit of the doubt of having early warning and everything going smoothly, when an applicant has the burden of proving that the hazard and the evacuation policies have been complied with. The benefit of the doubt doesn't go to them. The benefit of the doubt, given the extreme vulnerability, does not go to saying yes. Now, you know, Mr. Alexander testified to you that this rezoning, if it's approved, would add 30 minutes to the evacuation just of this area, Captiva Sanibel, and will increase evacuation times by some undetermined amount, because coming up with a specific number would require a lot of modeling work that can't be done at this time. Either way, those numbers, that impact violates the plan. Policy 5.1.2 prohibits residential development. Again, I reiterate that hotels have always been considered residential in Captiva, where physical constraints or hazard exists, or require the density to be adjusted. It goes on to say those constraints or hazards include flood, storm, or hurricane hazards. Policy 5.12 is violated. So is policy 72.2.2. Assess the impact of all new residential development, again, for Captiva, that includes hotels historically, upon the projected hurricane evacuation network and upon projected hurricane evacuation times. So, you know, the impact on an already unsafe evacuation time would be that it increases it. That cannot comply with policy 72.2.2. Goal 73 is to provide evacuation and shelter capabilities adequate to safeguard the public against the effects of hurricanes and tropical storms. Mr. Alexander's testimony is clear that this rezoning would not comply with that. Goal 101, protect human life along with current and future development from the impacts of coastal flooding, including the impacts of sea level rise, storm surge, and flash floods. Again, that applies categorically, whether you want to call it residential or hotel commercial, it applies to all development. Section 34.411F of the code, planned development, that's this, shall not create or increase hazards to persons or property. Categorically, all persons, all property. Here we're increasing the hazards, it violates that section. Section 34.413 that I've referenced a few times today, density or intensity in a planned development shall be determined case by case basis in accordance with the following. And under sub 2, among those following criteria are public safety. Objective 73.1 requires the county to move towards decreasing their overall evacuation time pursuant to the Southeast Regional Evacuation Model. His testimony was very clear, and even the generous testimony of the applicant's expert is that we're moving away from, not towards, bettering our regional evacuation times relative to Objective 73.1. Mr. Alexander explained in response to the applicant's argument, well, we've done some things over the years that have brought evacuation times down from where they had been. Mr. Alexander pointed out, no, actually, since we started doing those regional studies in 2010, those numbers for countywide evacuation have gone up, not down. And so we're increasing the entire countywide evacuation time. We're not furthering Objective 73.1. And I would, you know, and I want to say this, again, this rezoning has to look at all of those, but the biggest impact is on this particular island, this particularly hurricane-constrained, hurricane-vulnerable island. Trying to downplay, you know, let's do the rezoning, let's hope for the best, let's increase by 356 units. Mr. Trescott for the applicant, oh, let's just, you know, He did say, I modeled 100% occupancy. He said that. But he kept trying to get you to think that was somehow an overestimate. You're really, we're being over conservative because hurricane season doesn't totally coincide with peak season. Well, you know, you got July 4th, you got Labor Day, September's the low occupancy date, October, November, Thanksgiving holiday. You approve a rezoning like this, those units are permanent. They're not, there's no requirement that they can't be occupied during big weekends during evacuation season, hurricane season. You're making permanent decisions to increase the amount of people at risk based on there's times where there's low occupancy, based on there's times we're going to be able to get everybody off. That's not responsible planning, certainly consistent with the code and the plan as it relates to hurricane evacuation and public hazards here. It's impossible to interpret all the relevant policies and code sections here to say this plan, this code contemplates increasing by 356 the amount of development units at the northern tip of Captiva. There's no way you could read it that way. And of everything, density, intensity, community character, traffic, there's nothing more important than that hierarchy of public responsibilities as reflected in the comp plan and the code than public safety, life and limb. Sadly, the people of this county and people of Captiva and Sanibel have experienced that firsthand recently. The next thing I'm going to talk about is transportation. Mr. Rourke testified to you about major flaws in the transportation impact statement for this application. Not fully counting traffic relative to changing 140 employee units to now 193 2- and 4-bedroom condos. A lot of additional traffic there. Different increased size and use of multifamily units, the conference facilities, commutes by 1,000 employees that are claimed. He pointed out the transportation impact statement relies on outdated data, which he said underprojects the impacts. He explained that this idea of this park once concept touted by the applicant is illusory, not consistent with the reality of how this resort is used. You've heard testimony from him and from others that talk about, you can't walk. This is too big. It's not a walkable resort. People got to use cars. They got to use golf courses. People don't stay there. There's these great little funky neighborhood commercial facilities outside of the gates on Captiva. There's Sanibel Island and all the things it has to give. People move around. You can't assume that people are going to show up, park or Uber at South Seas, and never leave. That's his testimony as a traffic expert. He explained, I think in pretty vivid detail, the problems you're going to have, including when you fold in the deviations with expanded parking conflicts. Not enough parking spaces for everybody, and who bears the brunt of that? People that don't own this 120 acres that the applicant owns. He explained that the transportation deviations are inappropriate, major pedestrian conflicts, major golf cart conflicts, and he explained that forgetting, individual conflicts, just the traffic congestion impacts are going to go far past the adjacent roads. It's going to worsen congestion, including congestion on US 41 on the mainland. This testimony, I think, supports a conclusion that what will be violated if a rezoning is approved and the traffic impacts are allowed then, Section 34.612(2)D. The purpose of a planned development district is to, by avoiding negative impacts on surrounding land use and traffic circulation. That's violated here. So is policy 611 of the plan, which applies to commercial development. All applications for commercial development will be evaluated as to, among other things, traffic and access impacts. Those cannot be categorically found to be anything other than very negative here. The next infrastructure issue I want to talk about is fire and sewer service.
Okay, just hang on a minute. I need
Yes, ma'am.
I'll let you know when.
Mr. Grosso, slow down.
Next topic?
Fire and sewer service. Well, you heard Mr. Mintz made a presentation, Mr. Evans of SCCF made a presentation. The adequate wastewater treatment plant capacity has not been demonstrated by this applicant. The letters of availability put into the record are woefully inadequate to show enough capacity available to meet the demands of all of the new units that are requested. The capacity that is there comes from a treatment plant that sits in tidal mangrove wetlands and has a history of emergency sewage spills and doesn't treat to advanced wastewater treatment. The discharges to Pine Island Sound, it's already impaired by the state of Florida. It's already too polluted for nutrients. Adding reuse water to the golf course and landscaping has nutrients in it that ultimately find their way into a nutrient impaired body of water. And then there's the fire. You've seen the fire chief's letter from Captiva. You've heard his testimony. I've already addressed that, but there is not demonstrated adequate fire service capacity for this rezoning as we speak. As a result of fire and water, fire and sewer inadequacies, policy 2.2.1 is violated. It requires rezonings be evaluated as to the availability of central sewer and fire protection. Section 34.202A10 is violated of the code because it requires proof of sanitary sewer availability for rezonings. It hasn't been complied with. You know, the sewer issues relate to environmental issues. And, you know, what you heard from a group of scientists from the highly respected Sanibel Captiva Conservation Foundation. And they detailed for you great adverse impacts on both water quality and natural resources, including, importantly, wildlife habitat. I think it's safe to say those issues got pretty short shrift in the staff report and presentation by the applicant. Again, most of those impacts spring from just the sheer increase in people and vehicles that are going to be there, and buildings that are going to be there under the rezoning. The increased conflicts between human and wildlife, the interactions there. Vehicular-caused mortality. More vehicles from a substantially greater amount of units is going to cause more wildlife mortality through collisions. More noise from that development, more light. Noise and light are adverse to wildlife. Birds, turtles in particular. Beach and dune foraging and nesting habitat for shorebirds being disturbed by more people on the beach. And this area has a number, I'm not going to detail them, those folks did it for you, shorebirds that are state and federally designated. We're not talking about common wildlife here. We're talking about state and federally designated threatened and endangered species. They explained to you that federally protected sea turtles get disoriented by light. There's gonna be more light, a lot more light as a result of this development. They testified that birds will strike buildings both during the day and at nighttime. They explained to you that yes, we have lighting ordinances, yes, we have a noise ordinance. They can reduce to some extent, but they cannot prevent the additional impacts of the sheer number of people interactions, car interactions, building interactions. And we're not talking about some sort of ecologically unimportant area. We're talking about a coastal barrier island within a stone's throw of Ding Darling National Wildlife Refuge, Sanibel Captiva Conservation Foundation Preserve Area, City of Sanibel Preserve, and lands owned by the state of Florida. This is a very environmentally sensitive area here. So wildlife impacts matter a lot. Those folks detailed for you, you got some very, for example, the Sanibel Island rice rat. Why is it called that? It only is found on Sanibel Island. and the eastern screech owl. They are particularly at risk here because of salt water, and you heard Mr. Evans talk about saltwater intrusion and sea level rise. As fresh water resources get depleted, they have to cross the road more often in search of fresh water. More road crossings, more cars, more vehicular collisions. The code requirements, mitigation, those are window dressing that cannot overcome the density and intensity increase by adverse impacts on water quality and on wildlife. And the water quality issues, the experts told you, come from using reuse water on landscaping and on the golf course, and that water finds its way into the very sensitive Pine Island Sound Aquatic Preserve. I point out, it's a designated state of Florida aquatic preserve, a special water body that's to be afforded the highest level of protection. It's currently impaired. This is going to make it worse. And in particular, the nutrient pollution into the shallow waters will in fact affect seagrass beds that are the nursery grounds for all manner of fish and invertebrates like crabs. And the more nutrients in the water, the more the red tide that closes beaches will increase. More fish kills, more beach closures, more wildlife strandings as a result of red tide bloom. That's what the experts told you. So there's a lot of policies. I think there may be even more policies in this plan to protect the environment than there are to protect compatibility of surrounding uses, and there were a lot that meant to protect the neighborhood from intrusion for bad, adverse commercial and residential development. There's a lot that are violated here for the environment. Goal 113 of the plan, preserve the ecosystem that nourishes and shelters commercial sport and recreational fisheries. Objective 113.1, enhance estuarine ecosystems, not add more polluting development when they're already impaired. Goal 122, maintain or improve water quality, protecting wildlife diversity and reducing or maintaining current pollution loading. Goal 125, ensure that water quality is maintained or improved. The testimony makes clear that is not going to happen here. It will be reduced. Objective 125.1, again, maintain high water quality. We don't have that now. This is only going to make it worse. Objective 125.1.2, do not degrade surface and groundwater quality. Policy 101.1.1, development within the coastal high hazard area must be compatible with natural systems, such as wildlife habitat. There's no way that the facts presented by the SCCF experts could possibly result in a ruling that policy is complied with here. Same is true of policy 101.1.2, protect and conserve environmentally sensitive coastal areas, including estuaries, beach and dune systems. Policy 611 sub 7, all applications for commercial development, if that's what these hotels are going to be, will be evaluated as to environmental considerations. That evaluation is not a good one for this project. Objective 23, continue the long-term protection and enhancement of wetland habitats, water quality, native upland habitats, and beaches on Captiva, specific to Captiva and its natural resources. And I remind that the community plan support document made a point that the density limitations here were not just for public safety, were not just for community character and neighborhood compatibility, but also a reference to environmental protections. I want to move on before I conclude and just mention briefly about the deviations. They don't comply with policy 23.2.6 that requires all of the specific requirements for variances and deviations in the code be met. All. It's not a weighing and balancing thing. They all have to be there. They all have to be met, burden of proof on the applicant. And I mean, I don't know that a conclusion can possibly be made with all the testimony we've had here that all of those conditions have been. If I triggered something?
It's over here. Mike is gone.
if it's not bothering you, I'm happy to.
I can hear you, unless we
Okay.
need to evacuate. What is that? Okay.
Excuse me, Your Honor.
You outlasted the battery.
Thank you, Mayor. Thank you, Your Honor. They don't comply with all of the criteria in the code. Section 145B3B says deviations aren't allowed if they're the result of actions of the property owner. Section 331615B don't allow deviations on Captiva unless a whole litany of things is complied with. 1, the hardship can't be corrected by other means. 2, strict compliance of the regulations allows the property owner no reasonable use. Another is the applicant didn't cause the need. And another is that the variance or deviation is the minimum one needed to make a reasonable use of the property. Now, clearly, they've got a reasonable use of the property. It's already been built out. They've got all those units on 120 acres that they are entitled to. So the deviations are not necessary to allow a reasonable use of the land. They already have that. Now, I think there's an argument that, well, there was an ordinance adopted last year in 2023 that exempted South Seas from these requirements in the code. And the legal point I would want to make to you about that, Your Honor, is when policy 23.26 in the plan says all of the specific requirements for deviations in the code must be met, that has to be interpreted to mean as they existed when policy 23.26 was enacted. If one were to interpret that policy in a way that says, well, all we got to do to change the policy in the plan is to just change the code, exempt people from the deviation requirements in the code, that is an inappropriate interpretation of a comp plan. One cannot read a comprehensive plan to be self-amending. It's an inappropriate reading of a comp plan to allow it to be changed, its terms, its requirements, by a subsequent code change. I hearken back to the point I made when I got up here this morning talking about that. The code always prevails, and the case law has made clear, and I would point to you 163.31771B that requires an incorporation by reference in a plan has to specify the exact edition of the document being adopted by reference. I've cited you in my letter, the Florida Wildlife Federation versus DCA, DOA final order of about 20 years ago, that you can't allow code changes to change the substance of what a plan requires. So our position would be that policy, that code change to somehow exempt South Seas Island Resort from having to meet the deviation requirements in Chapter 34 is of no moment. It's legally inappropriate, can't read the plan that way. Otherwise, whatever the plan says at any given time, you can just change later by subsequently changing the code. Can't do that under Florida law. And then a couple of more points on the deviations. You know, there's been, I think, an argument that the application goes on several times about how, well, we're not seeking deviations that are categorically different than what we were allowed before under the ADD development. Well, okay, those deviations may have been appropriate given X amount of development, but now those same deviations are not necessarily appropriate with 356 additional units of development. So, you know, if they were vested to certain deviations at a certain development intensity, that surely does not, as a matter of law, authorize greater deviations in the face of more intense development. Florida law is clear. There is no right to expand an existing non-conforming use. I've cited to you in my letter the marine attractions versus City of St. Pete Beach case. That can't, prior deviation to X amount of development cannot support new deviations for X plus 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 amount of development. Deviations have to be denied. They haven't demonstrated compliance with all the requirements. And I won't get into Mr. Patterson and Mr. Witt and Mr. Suarez and some of the detailed testimony that you've heard about that. But the deviations have to be denied. And perhaps the overarching point I'd make about the deviations before I'm done with those is that they prove this is too much stuff. They prove this is too intense. Why do they need all these deviations? They're trying to put 356 more development units than this piece of earth can handle. Environmentally, community character-wise, roadway network-wise, mobility-wise, any way you look at it, there's too much stuff to fit with this rezoning application. That's why they need the deviations. That probably is the biggest take-home message from the need for all these deviations. It proves the incompatibility of this intense amount of development being requested. That's why the rezoning has to be denied, and conditions won't cut it to make it appropriate. I've got, before I conclude, I think we were given the opportunity to present some questions
Yes.
to the applicant, and I haven't done this before, so I'm not sure how you do this, but with,
Why don't you read them aloud, and then if you have them printed, give a copy to staff and the applicant.
I've got several of them, and I don't know if you want me to read them aloud. I could hand them out and give them to you and have the applicant have to address them or the staff address them. But
I
you
would
are
like you to read them aloud.
okay.
But if you have a copy, I'd welcome a copy.
Yes, and I had brought copies for all.
Okay, thank you.
And these are questions for applicant and staff to respond to.
For applicant and staff, yes, Your Honor. And
Okay, this will be Grosso Exhibit 2.
And if it's okay, Your Honor, if I could read them off the copy that I would give to you
Yes, and then
first.
give it to me, okay.
And there's a set of questions that are tied to some documents as well. First question we would put would be to Mr. Roberts and Mr. Baracco.
Can I interpose a question or objection? I read ahead. This isn't regarding the rezoning. It's regarding a pending application that's permitted currently. So what do we
Okay.
do with this?
So in my introduction, and I explained that the public can ask questions, that staff and applicant will answer them to the degree necessary.
Okay.
And if, in your opinion, the question is not germane to the zoning application, then it is your choice not to include it, a response to it when we get back to staff and applicant following public.
Okay, thank you.
So we would ask that Mr. Roberts and Mr. Baracco answer the following questions. What is the minor change related to the water park Track C development order that's currently under review by staff, seemingly filed by the applicant on February 14th of this year during the HEX hearing and assigned case number DOS 2023-00182-M01? The submittal and any staff comments are not available on the county website, but the Acela landing page notes the revision related to the landscape berm and elevations, among other things.
That might be better suited to a public records request, but please continue. I'm not
Okay.
intending to derail you. I'm intended to help you.
Yes, ma'am. Second question to Mr. Roberts and Mr. Baracco. The applicant's May 30th, 2024 response to staff's insufficiency letter of May 1st, 2024, which notes that the submitted plans do not meet the required setbacks from South Sea's edge of pavement, nor for the proposed pool equipment or restroom building along Bayside Villas, provides that a table on sheet 4 of the revised plan, which we attach to this question, includes setbacks from the structures with measurements to the property line to demonstrate compliance with allowed setbacks per Land Development Code 10-329 sub D sub 2. The water park is already under construction. Are the setbacks per the Land Development Code being met? We next have a question for Planning Manager Mr. Dunn of the county. Is it true that the 5 acres of commercial use set aside in the 1973 resolution and recognized in ADD 2002-00098 was not for residential dwelling unit or hotel use, but instead a small commercial area to provide necessary goods and services to resort visitors and property owners in the future. Second question for Mr. Dunn is it true that the ADD provides for physical extents of a contiguous 5-acre commercial area on the south end, only as depicted on Exhibit D to the ADD? We would have another question to Mr. Price, the Transportation Division Chief of the county. Is it true that during evacuations, the affected roadways experience reduced efficiency and flow rate and increased congestion due to reduced flow during nighttime hours, weather conditions, disabled vehicles, more cautious and anxious drivers, and increased traffic volumes compared to regular traffic? For the applicant, we would ask Ms. Crespo to address the following question. During your presentation at PowerPoint slides 20 and 89, you indicate that the county attorney's office notified the applicant in 2023 that section 34-1038 is no longer available. How was the applicant notified by the county attorney's office? If that's in writing, please submit. Next question from Ms. Crespo. Why is the Beach House Restaurant, Track G, recognized as commercial on the development order application 2022-00196-A02, also attachment S to the staff report, but not reflected as commercial on the proposed MCP and instead reflected as resort recreation? For Mr. Baracco, we would ask to respond to the following 2 questions. Madam Hearing Examiner inquired as to where golf cart parking will be included, and Ms. Crespo declined to answer and deferred to you, but you did not answer this question as part of your presentation. Where will the golf cart parking be provided? Number 2, your office filed the development order application that included the Beach House Restaurant. Why is the Beach House Restaurant recognized as commercial on that development order application but not reflected as commercial on the proposed MCP? And for Mr. Trescott, we would ask, is the following passage from page 1 of your January 2025 report accurate? And to paraphrase that report, the entire SSIR property is in County Evacuation Zone A defined FEMA Special Hazard Area, Coastal A, Coastal AE. Most of the property is located in the FEMA designated Coastal High Hazard Area, Zone VE and Coastal Zone A. For the purposes of hurricane evacuation, Evacuation Zone A is also defined as the Category 1 slosh model area. Is that true? You put it in your report. The next question is it true that the roundabout at the intersection of Causeway Boulevard and Periwinkle Way that you mentioned in your report is theoretical only and does not exist and has not been funded or approved for construction? Also for Mr. Trescott, is it true that several high occupancy periods fall within hurricane evacuation season, including 4th of July, high occupancy months of October and November, Labor Day weekend, and Thanksgiving? Next question. Were the unit occupancy rates for Sanibel and Captiva, upon which you based your analysis, based on occupancy rates for the month of September, which you acknowledge would be low, because September is the month that probably has got the lowest occupancy rate? Next question from Mr. Trescott. Is your analysis based on the assumption that only 42 homes of the 1,773 units on Captiva would be occupied and only a total of 35 vehicles would be evacuated? Next question, is it accurate that Hurricane Otis in 2024 began on October 24th as a tropical depression and became a Category 5 hurricane and made landfall near Acapulco in 24 hours on October 25th, and that tourists were still being evacuated on October 27th? Final 2 questions from Mr. Trescott. Do you know why the parameters for the base scenario as outlined in your report were set? Last question, is it true that you did not personally perform any of the evacuation clearance time calculations in the statewide regional evacuation study program? For Mr. Van Rintelm, we would ask the following questions.
Pardon me, who is this for? Who's the question for?
Mr.
This is for someone who didn't testify in the case in chief, but who did testify in the DOA proceedings, so I'm assuming we're under no obligation to produce them here.
Okay.
Okay, then I'll move on from that person's question
Okay.
for that person. Okay. Ms. Fountain, I believe, testified for the applicant. Questions for her. Is it accurate that for purposes of land use and development decisions in Florida, Chapter 163 Florida statute makes the slosh coastal hazard area the relevant coastal hazard area? Is it accurate to say that FEMA changes the base flood elevation were made to respond to the fact that the land on which South Seas Island Resort sits is vulnerable to significant storm surge? Also to Ms. Fountain, is it true that during Hurricane Ian, several segments of Captiva Drive were completely overwashed and damaged by storm surge? I've got two more brief sets of questions. For Mr. Gallo, based on the transportation engineer's stated expectation that guests will arrive at the resort and have no reason to leave, is it accurate that the expectation for off-site positive economic impact will reflect that situation? Second question to Mr. Gallo, is it true that your economic impact analysis did not include any analysis of any financial demands on taxpayers that will be created or increased by the expanded resort? For example, costs associated with fire, emergency management, and police, evacuation management, and hurricane and storm surge drain damage cleanup, code enforcement, and solid waste management. And then three final questions for Mr. Farrell. In your email to Ms. Crespo of June 7th, 2024, which was included in the applicant's resubmittal to the county on July 24 of 2024, you indicated that there are currently 3 employee shuttle vans and you expand as the staff grows, and you indicated that as many as 14 employee shuttles daily have been operated for the resort. How many shuttles are anticipated to serve the proposed development? How many employees have historically been on each shuttle? Second question, during your presentation, Attorney Montgomery asked you how many units outside the resort property participate in the resort's rental program and will be subject to its evacuation plan, but you didn't reply with a number. How many units outside of the resort owned by others participate in the resort's rental program, and what's the forecasted participation rate for the next 12 months? Final question to Mr. Farrell. Is it not likely that guests who arrive by rideshare or shuttle may be unable to secure that same mode of travel off the island in the event of an evacuation? Those are the questions, if I may present to you.
Yes, thank you. This is Grosso Exhibit 2.
Thank you.
Thank you.
To conclude, Your Honor, as you weigh and balance the presentations and testimony that you've heard, you know, I would ask you to consider just a couple of considerations. The ability of the applicant's attorney to direct questions, indeed multiple leading questions to presenters for the applicant. The inability of lawyers on, you know, for the opponents to be able to do the same thing, direct questions to folks and ask leading questions or put cross-examination questions directly to people. Certainly that's what the code says. And we appreciate the courtesy we've been given under the code. But I think as you consider the weight and credibility, I think that's an important factor to consider that probably comes into play. Either way, and even pending the questions we've put into the record, I think there's no view of the record, the facts, the evidence, the presentations, under which it can be concluded that the plan and the code criteria are met here. I have detailed a bunch of code and plan violations, but I'll focus at this point on the specific findings that you must make as a result of this proceeding. Section 34-145, sub D, sub 4, sub A, requires findings for approval. And again, we would certainly ask and urge you to make very specific findings of fact that are very specific to the language of the code in the plan sections that are implicated adversely by this amendment. For rezonings generally, Section 34-145 requires that the applicant demonstrate, number one, compliance with the plan. They have not. Number two, that it meets the code in all applicable regulations. It does not. Again, to reaffirm, specifically here under Section 34-145, it must be found that the proposed development rezoning is compatible with existing and planned uses in the surrounding area. I just don't think the evidence could possibly support a positive finding there. It must be found that the rezoning will provide access sufficient to support the proposed development intensity. There's the narrow access on and off the island. That's the access on and off the island. And then it's also the access within the development in terms of how constrained and interrelated that is with other people and the conflicts. It must also be found positively that the rezoning will not adversely affect environmentally critical or sensitive areas and natural resources. Surely the weight of evidence precludes a positive finding there. And then 34-145 D4A sub 2 requires specific to planned development rezonings that the hearing examiner must also find, A, that the proposed mix of uses is appropriate at the proposed location, and that mix of uses, as you've heard, in terms of what's already on the ground as a result of this cohesive master development plan, this wrecks that mix of uses. It was carefully crafted, it was carefully built to provide the right amount of amenities and open space and complementary commercial and residential and hotel, and now this would blow that apart. It is not an appropriate mix, certainly not at this specific proposed location. The plan and the code violations are multiple. I've already read them to you. There's nothing that recommends this. There's nothing positive about this. Everything is adverse. This rezoning is everything this plan and this code do not want at the northern tip of Captiva. Nothing to support. It's incompatible with existing and surrounding uses. There's not enough room to comply with everything in the code. Look at all the deviation requests. It's incompatible with the surrounding and nearby development. You've got a landmass that's shrinking as a result of sea level rise. It's not getting bigger, it's shrinking as a result of sea level rise. And that's not just the landmass shrinking, that's salt water coming up from underneath. That makes that treatment plant even more vulnerable. That makes the application of pesticides and fertilizer and reuse water, it gets into the water even quicker because of sea level rise coming up from the ground, not just over from the sides. The environmental and the habitat impacts are all adverse. The best they can show you is they won't be quite as bad if we comply with some standards in the code. But increased, absolutely. Adverse, absolutely. Public safety, the most paramount requirement that there is. Evacuation will get worse. It's already dicey. It will only get worse. They can downplay how much worse it'll be, but it's categorically worse. Storm surge, flooding, public safety, it's worse. And it's already in a vulnerable location. It's not making it worse somewhere that's high and dry on the mainland, it's making it worse in the most hurricane storm surge vulnerable location in the county. Traffic, already congested, narrow one road in, one windy road within SSIR, that is what all the other landowners rely on for their own convenience. It's gonna get worse. All those things require finding of violations of the plan. there are the two essential violations that just stand out. And, that's the community plan policies. Just the record is clear. The historic development pattern by this unique construct of SSIR, Master Development Plan, tightly controlled, reaffirmed over years, 912 units. That includes residential, that includes hotels. That's unequivocal. This is not in keeping with that. It's a major expansion of that with all sorts of adverse impacts on character, integrity of the residential neighborhoods, and all the other issues I've talked about: traffic, evacuation, environment, quality of life, everything else. There's no way to read Chapter 23 to allow an expansion, not a maintenance of the prior existing development pattern. There's no question of what that prior existing development pattern is. Very constrained, very limited to 912. And then the second one, the public safety, which I've already gone on. You can't condition public safety. You can't require them to increase the capacity of the roads. You can't put window dressing on a development that's far too intense for this area environmentally, public safety-wise, evacuation-wise. The requirements in the code are for density and intensity to be keyed on a case-by-case basis based on what's appropriate at this location. Obviously, the facts can only be found that this increase in development is not appropriate at this location. It's a fully built-out project. Vested rights are recognized in the comp plan. Expansion is prohibited by the comp plan. Recall the community plan support document provisions that tell us why that chapter was put into the comprehensive plan. This rezoning would come at nothing but the expense of all the other owners out there at South Seas Island Resort and my clients, members who live just outside the resort, and many of whom live within the resort itself. This can only be proved on the backs of all those people that adversely affect their property rights, their community character, their public safety, their environment. That's the reason people live and visit out here. This rezoning flouts the very purpose and the intent of the whole master development planning process, the purpose and intent of Chapter 23 of the comprehensive plan, and all the other provisions of the plan and the code. On behalf of the Captiva Community Association, we would ask you to make very clear, very specific findings of fact and recommendations as to why this rezoning cannot possibly comply with the Lee County Plan and Code. I thank you very much for the opportunity to present to you this morning. Thank you.
Thank you.
Madam Hearing Examiner, I have a question. Under the administrative code, obviously I understand that if that's legal argument, which it sounded like, I'm not allowed to ask Mr. Grosso any questions. If he's a fact witness, then I am. So was that legal argument?
I'm happy to answer any of Ms. Montgomery's questions, but to be clear, I was making legal arguments. And
Well, no, I don't want to break the rules. If it's legal argument, I will.
Okay, I will allow it to a limited extent, but remember my admonition from before and what information is helpful to me and the board.
No, if it's legal argument, I'm happy not to ask questions.
Okay.
Well, let me be clear, Your Honor, just to make any misinterpretations. I'm a lawyer, and I did not claim to be making factual presentations to you. I was commenting on the other record. So
No, and that's how I understood it. I just want to make sure we were all on the same page.
Right.
Thank you.
thank you.
Can he take his seat?
Pardon me? Oh, no.
Make him take his seat? Or are you going to ask questions now?
No, I'm not going to ask questions. If it's legal argument and it's not fact, confidence, substantial evidence, I'm not going to ask questions.
Okay, thank you. You may take your seat.
Thank you, Your Honor. Thank you, Madam Court Reporter.
All right, so the time is noon. I think that we can continue with at least another witness if that witness thinks they're going to speak for less than 15 minutes? Yes. Okay. I want to be sensitive to the court reporter, so I'm keeping an eye on that hour-and-a-half mark. So I think I can, in good conscience, go to 12:15. Good morning.
Good morning, and thank you for allowing me to speak. I'm Jay Brown. I'm a resident of Captiva for 27 years. I live on the Tween Water stretch, which is my house is about a mile from the entrance to South Seas. In addition to being a resident on Captiva for 27 years, I've served over 10 years on the Captiva Community Panel, and for many of those years, I was president of the panel. So I feel like, given my long history of living on Captiva and my service on the panel, I have a very good understanding of what makes Captiva so unique versus other Florida coastal communities, and why we all live on Captiva rather than in Naples or Palm Beach or any of the other communities that prize being cosmopolitan over preservation of their natural habitat. We are a community of small-scale buildings, low density, and respect for our natural habitat. That's what makes us unique and special in the state of Florida. What's being proposed to you by Timbers goes against everything that we stand for on Captiva. It goes against all the reasons why we live on Captiva. If you approve this, you're going to change the nature of Captiva. You're going to make it far less desirable for us to live on Captiva. Perhaps even more important than this decision here that you're about to make is the precedent that would be set by approving this. How can you approve this without approving whatever other development plan comes before you? So I ask you to really think about the precedent that you will be setting here, not just what it's going to do to us if Timbers gets the approvals they're seeking from you. I want you to understand how small Captiva is. There are 1,200 taxable parcels of land on Captiva, 1,200. About 600 of those parcels are in South Seas, and about 600 of them are outside of South Seas. If you allow 350, whatever the number is, something over 350 units beyond what exists in our long-standing land use policy, that is a major impact on Captiva. I mean, think about that, how small we are, 1,200 parcels. It is a big impact. We are a small, community. Think about having a 200-plus room hotel right at the entrance to South Seas, which is right adjacent to our quaint village area. Do you not think that's a major change in the character of what Captiva is? It's a huge change. There's been a lot of discussion about, well, how do we measure building heights? I think you can throw all that out. The people on Captiva have long believed that you should have 2 livable floors above base flood elevation. Everybody's for that. Timbers has argued that their height, requirements are required for resiliency purposes. That's just nonsense. Resilience is a function of how high your first floor living area is above base flood elevation. Having 3 livable floors, in some cases 4 livable floors above base flood elevation, does not improve resilience. It harms it. Low building heights with trees growing above, our buildings, surrounded by native vegetation. That's essential to what our island's charm is. And it's essential to our uniqueness among Florida coastal communities. Tall buildings, such as a hotel with parking underneath, 3 livable floors, is a major change in the character, of our island. We do have a few buildings on Captiva that are built beyond what our 2 livable floors are, but those were built long before our long-established land use policy has been that we've been adhering to for the past 30 years. So I urge you not to pay attention to that. Those buildings were built mostly back in the 30s. We talk about, is what they're proposing consistent with our historical land use policy? Well, if it's consistent with our historical land use policy, why is everybody on Sanibel and Captiva opposed to this? If this was consistent with our historical land use policy, you wouldn't have had a petition with 13,000 signatures on it go to the county commissioners. You wouldn't have had over 5,000 emails go to the county commissioners urging them to respect our longstanding land use policy. I just think the fact that everybody universally, is opposed to this demonstrates that we do have a longstanding land use policy. And that longstanding land use policy is the reason why we're all here. Please don't change it. There's been some discussion about the fact that Captiva properties outside of South Seas are on septic tanks, and we don't have a central sewer system to service those properties. One of my major tasks on the Captiva Community Panel has been to establish a central sewer system for all the properties outside of South Seas. We've completed all the engineering for what the central sewer plan would be like in our village. We have the plans for that. We're working to establish a partnership with the city of Sanibel to process the wastewater that would be collected. In pursuing this project, the major negative I have heard from people on both Sanibel and Captiva is the fear that if we establish central sewer for Captiva, that will encourage unwanted development. It'll make it easier, for people to convert, their properties to more intense use. I own 4 acres. If we have central sewer, it's a lot easier for me to construct maybe 12 condos on my property. It's a lot easier for me to do that if I have central sewer than if I have to worry about what I'm going to do with the wastewater. So that has been the major negative feedback that I've always gotten about establishing central sewer. And I have answered that question time and time again. Folks, don't worry about it. We have long-standing land use policies in place. We have strict codes in place. Central sewer is not going to lead to more development. We're protected by our history. Don't worry about that. If this project goes through, I think the central sewer project on Captiva is doomed. I'll lose the public support. As property owners on Captiva, we've made major investments, to purchase and develop our properties. We did this because Captiva is unique. We didn't want to live in Naples. We didn't want to live in Palm Beach. We wanted to live in this quaint, small community with low density low building heights. Think about all the people inside South Seas now who bought under the assumption that the land use codes there were gonna stay. They didn't buy into this thinking that there's gonna be 400 hotel rooms, hundreds of additional golf courts running around everywhere. You know, destruction of a lot of the greenery and everything that exists. They didn't buy into this. They bought into a promise that South Seas, as you see it today, is what it's gonna be in the future. So I ask you to think about, you've got a developer here. You know, I understand, you know, I spent years in private equity myself. I've, you know, done projects, you know, like this. But you've got this group of people, but you've got all the people in South Seas and outside of South Seas whose lives you're going to impact in a very dramatic, negative fashion if this goes forward. Thank you for hearing me out.
Thank you. Okay, listen. Thank you.
Yeah, Mr. Brown, if you would,
Yes, sure.
can I trouble you to ask?
Yeah.
You indicated you've been a resident for 27 years.
Yes.
Are you a year-round resident or a seasonal resident?
Seasonal resident for the first 17 years, year-round the last 10 years.
Okay, and during the time that you've been on the island, have you done a lot split with your property?
I'm sorry?
Have you done a lot split on your property?
I did do a lot split.
And did you build a new approximately 16,000 square foot house?
16,000 square foot house? No, 6,000.
6,000, okay. And so you have a 6,000 square foot
Right.
house and you have the original historic house.
I have, the original historic house was a cottage in the center of the property built in 1945.
Which is still there,
Yes.
and you rent that house, correct?
No, my property manager lives in it.
Okay. So do you have any other houses?
I have a house on the back, which is in a seasonal rental program, and then the house I have in front,
Okay,
built in a coastal style that is similar to the architecture that exists on Captiva.
okay, so you have increased the number of units on your property
I
since
have.
you've been there. So
Yeah.
you have made it more dense or more intense,
No, I don't think so.
but you've added 2 houses.
Yeah, I have, but, you know, one
Okay.
was my main house, and I have a different main house. I built that house when I decided to live here full-time.
Okay, thank you.
We are going to break for lunch now. We will resume at 1:30. Thank you. Everybody ready? Yes. Okay, we're in the public input portion. My understanding is that the next speaker is going to be Bill Finley. Oh, you're already in the chair. Hang on 1 second here.
I'm pretty much going to read it, so I'll give you a copy.
Okay, and do you have a copy for the court reporter by any chance? Okay, good.
Gave him one.
Mr. Finley, so in terms of exhibits, your written version of your statement is going to be your Exhibit 1, and the paper copy of your PowerPoint presentation will be your Exhibit 2.
Can your office provide us with a copy of the PowerPoint? Is that possible?
Speak to Maria, and we'll get you one.
Okay, thank you.
It's 2 pages.
Introduction. Should me to start?
Okay, just give me a moment to mark the exhibits, and then I'll be ready for you to start. Thank you for your patience. You may begin.
See if you can hear me. My name is Bill Finley, and I am president of Marina Villas, a condominium complex with 40 units located on the east side of the main marina on South Seas. Our community consists of 4 two-story buildings, each containing 10 condos, with air conditioning and storage beneath the units. While I am not a recognized expert witness, I have firsthand experience managing the recovery of our condos following the last 3 hurricanes. Having lived through these disasters, I understand the challenges they bring and the importance of practical, effective solutions. I believe the country has come around to appreciate that basic common sense is invaluable. I have 3 major issues I would like to discuss: the 912 limit, including hotel rooms, the one-stop resort concept, and number 3, safety, parking, and congestion. I'm going to discuss the 912 limit. We bought here for the special ambience of a tropical paradise. If we wanted a densely populated area, we would have gone to the East Coast. It's a very small island. We can see the water from the Gulf of America out of our lanai. Although we have reconciled with the fact that the new condos may eliminate our view. We can see water in the bay from our kitchen. We can see these 2 bodies of water from our condo, not because we're so high off the ground, but because the island is so small. A group of owners are so upset that they are looking to launch a class action suit over the fact that they bought here with limited density in mind. They bought under the idea of a limit of 912. If the county thought the 912 was flawed, did they disclose it to other owners when they sought to purchase their properties? They did not. The applicant's own PowerPoint slide included hotel rooms in the 912 unit cap. You have heard prior testimony that the 912 included hotel rooms. There is a concerted effort by the applicant to confuse the meaning of dwellings. It is evident that dwellings include the applicant's proposed 435 hotel units. Otherwise, there would be no reason for South Seas to file its appeal in the settlement agreement case decided by Judge Schenkel.
Any discussion of civil litigation outside the scope of these proceedings?
Continue.
The unit count is a central issue. If the 912 cap is maintained, many of the other concerns will be eliminated. I'm going to address an issue that arose at the resort while the hearings were taking place. Timbers has sent out a directive not to assist the associations anymore. Our landscaper informed me that Timbers told him he could no longer park his semi-truck on their property. We have been using recycled water from the waste plant, which is owned by FGUA. The resort-owned pump house supplied water for our landscaping, which also benefited the resort by disposing of the effluent. Anticipating that the resort might cut off our water supply without notice, we secured a permit for our own water well and began the drilling. Timbers recently asked our landscaper how close we are to completing the project, as they will no longer provide us with water. When we went to check, we discovered that the water had already been shut off. I feel like I'm in a John Ford movie where the land baron has cut off the water to my cattle. We had to delay our replanting, and the question, do they want the vegetation to die? Previously, they stopped trash collection with short notice. In fact, once the hurricane hit, they stopped all trash collection, even though our association needed it. Do they want the trash to pile up? Now, I have been informed that the resort has instructed the associations to restore the cleared culverts back to their previous conditions. Do they want sand and debris put back in the culverts? Timbers has acted like a bully. These actions will only make the experience worse for both owners and guests. The relevance of these instances reflects the applicant's attitude. Before I spoke, 2 owners who together own 5 properties at the resort told me they are afraid of retaliation by Timbers if they chose to speak. I want to clarify that I am not against the resort. I have a good working relationship with resort staff. I have worked closely with the guest staff as issues arise. While we may have different opinions on further resort developments, we need to cooperate on a daily basis and keep the zoning issue separate for you, Madam Hearing Officer. My second point concerns the one-stop concept, which I call the Hotel California proposition. You can check in, but you can't leave. The beauty of Captiva lies in the connection to our sister island, Sanibel. There are so many great places to visit on Sanibel that I don't need to list them all. A few highlights include Ding Darling, the Shell Museum, the Lighthouse, the Farmers Market, events at the Community House, and scenic walking trails like Pond Apple. Captiva also offers many attractions beyond the resort. For example, the famous Bubble Room, which has its own Facebook page with 23,000 followers. If you look on social media, you'll see many comments and questions, wondering when the Bubble Room will reopen. The Mucky Duck is also famous. When discussing vacations, if Captiva or Sanibel come up, people always ask, have you been to the Bubble Room or the Mucky Duck? The Green Flash offers a panoramic view of Pine Island Sound. Andy Rossa Lane is home to a variety of shops and eateries. Tween Waters has multiple dining options. In my experience, people leave the resort in a vehicle to visit these sites and restaurants. My understanding is that the applicant will be offering interval ownership. If they sell an individual ownership for a 2-month stay, those owners will definitely leave the resort to visit local sites and restaurants. It has been suggested that Uber or Lyft could be used for transportation. However, people have not had success getting Uber or Lyft to leave the resort. It's unrealistic to assume that guests will only stay at the resort. This will ultimately lead to increased traffic and safety concerns. My third point focuses on parking and congestion. We have 40 units at Marina Villas. We have 44 parking spaces. As golf carts became more popular, we started to have parking issues. The vehicle parking is typically more than one per unit, a car and a golf cart. The condos can hold up to 6 people, so sometimes there are 2 cars plus a golf cart. We built a golf cart lot with 20 spaces. Although as 6-passenger carts become more popular, the space may hold less. We had tags made up to put on carts to park in the car spaces to move them to the golf cart lots. In season, we have to check the parking lot every day and put these on. I am not aware that any of the other associations have the space to do it. Planned parking at the resort is inadequate. We were told by the applicant that there's plenty of cart parking, including at the North Pool. There are only 10 charging spaces next to the pool. Owners in the rental program who have their own golf carts are told not to park in the cart lot, as the resort reserves those spaces for its carts to charge. Instead, they are instructed to park in the car lot. With the addition of a new restaurant, spa, and condos, we are now considering installing a gate at Marina Villas to prevent overflow parking from impacting our property. Continuing with the issue of parking and congestion, the employee housing was in disrepair and has now been demolished. Most employees did not have their own cars, so converting these units into condos will significantly increase both traffic and parking demands. I'm going to go to see if I can do this. As I mentioned before, we are located on the main marina. And you can see, so we're the main marina, Marina Villas. You can see proposed below that additional condos. To the left of that is existing timeshares. Slightly to the north of that will be the spa, and then to the left is where they built the beach house. Currently, there are 3 undeveloped areas, and the 4th is where the beach house is being built. This means that the 2 condo associations, ours and the new ones, and the spa will all spill onto that road, that small road.
Where's the spa? I'm confused.
It's on the, go up right there, right there, where it says Tract F.
Proposed resort recreation?
Right. So you
And
got the
that's on-
spa, the timeshare, the condos, and the other condos, and we're all going to spill onto that road and into the intersection.
Okay, the paper copy you gave me doesn't match what you put on here.
Should.
Service and loading location, okay. I see. It's just truncated. All right, and the point you're making, sir?
I'm talking about the traffic and
Right.
congestion that will be there. So additionally, as you can see, there's a curve in the road that limits visibility, making it difficult to see around the corner. You can see how it's curved at the bottom of the marina. This small road connects to Plantation Road, creating a 4-way stop. Across the road is a beach house, meaning all this traffic will funnel into that intersection. It was mentioned that there would be parking at the spa, but during the New Year's Eve party, I walked over and saw traffic officers managing the area. Cars and golf carts were already parking where the spa will be built, and the lot was full. Once the spa is completed, there'll be even less parking spots available. Also, where is the expansive bicycle and pedestrian network? I have owned here for almost 30 years, and I have yet to find it. Marina Villas uses a beach easement located by the restaurant. I have heard the argument from Michael Witt that the beach easement is an access road. I would like to direct your attention to slide 3. These pictures were taken March 14th, 2025. As you can see, 5 vehicles are parked on the easement for the wedding party. One of these vehicles is a truck clearly marked South Seas. These vehicles are parked directly in front of the restaurant entrance. My conclusion is that the applicant agrees that this is an access road where parking is permitted. To borrow from Johnny Cochran, if the buffer doesn't satisfy, you must deny. Before I summarize my final conclusions, I have a few questions. Why were permits issued before deviations were requested or approved? We saw what happened with the beach house. Why is the water park moving forward despite ongoing questions about the buffers? It has also been stated that the construction of the spa has begun, but it hasn't. In conclusion, we ask that the applicant be required to stay within the 912 unit limit, including hotel units, which we understood to be the cap when we purchased. Doing so would help alleviate many issues and begin to heal the community. Number 2, let's be realistic. Guests and owners are not going to stay confined to the resort. The increase in units beyond the 912 will exacerbate an already terrible traffic problem, will increase evacuation times, and undermine public safety. Number 3, there is no realistic parking plan presented to support the increase in units. Common sense tells us that there is insufficient parking for the proposed. Thank you, Madam Hearing Officer, for your time.
Thank you, Mr. Finley.
I have a couple questions, if I could, for Mr. Finley. Mr. Finley, in the ADD, which is controlling presently, it says 1 space per multifamily housing unit is required plus 1 parking space for every 10 dwelling units.
I can't understand you.
Can you hear me now?
Yeah.
Under the ADD, 1 parking space is required for every multifamily unit and 1 extra space for every 10 units. So your 44 spaces is consistent, is it not, with the current approval?
I can't represent that.
And are you aware that the parking requirements will change and more parking will be required when the project has to comply with the Land Development Code as opposed to the ADD?
I'm not following you. All I'm saying, I haven't seen any that there was going to be no parking at the beach house and it was going to be at the spa. You're saying there's going to be more parking now?
The parking now is set forth in the ADD. That's where the requirements come from. Should the zoning be approved, the parking requirements will be per the Land Development Code, which in most instances is more parking.
But I understood there's going to be no parking at the restaurant and that.
The beach house was approved under the ADD, not the current, not what will happen in the future, potentially. So let me ask you a
So
question.
you're saying there's going to be parking there at the beach house?
I'm just telling you what the situation is, that the beach house is under the requirements of the ADD.
Right, I'm just saying there's no parking there and there's going to be a lot of congestion coming into that 4-way stop and there's not enough parking at the spa. That's my point.
We will, yes. I understand your point, and we'll address that further on rebuttal. Let me ask you, do you have your own association for your 4 buildings, or are you part of a master association?
We have our own association.
And is there a master association that you're a part of?
We're just part of the Marina Villas.
So you're required, as your own association, to handle your irrigation, your parking, your trash, because you're not part of a master association, correct?
Correct.
That's all the questions I have. Thank you.
Next speaker. Is it Marilyn Frederick? No? Did I lose the new sheet? Sadowski?
Thomas Sedlowski.
I already lost it. Too much paper. No, these are people who spoke. Is that an extra copy? I can't be trusted.
Mr. Mintz, perchance, do you have another copy of the witness list so we can follow along?
We can give you, I lost the copy he gave me.
Uh-oh.
Is this your exhibit? Sure, I'll take that. What, is it like a, is it a PowerPoint? All right, and you're gonna be going through it?
That's
Okay.
not it?
No, this is the second one he gave me.
It's 2 pages, right?
Yeah.
Yeah.
I took a copy of the,
It's all right, he gave me a copy. You wanna give one to Neil?
I took a picture of it on my phone. It doesn't help.
I'm reading off their names. That's, no, this is the new list now.
Okay. All right.
Afternoon.
Okay.
You should be able to get to your next one just by scrolling. Yeah, just those 2 slides, so we can scroll between the 2. Yep, exactly. Use this.
Okay, Mr. Sedlowski, you gave me a composite exhibit of a couple of documents that you're going to be
Discussing.
showing up there. Let me mark that.
I won't be showing those 2 documents on the screen. I'll just be referencing them in my
Right.
notes.
We're just gonna make them part of the record.
Mhm.
Composite Exhibit 1, T. Sedlowski. You may begin.
Hi, Thomas Sedlowski, President, Bayside Villas Condominium Association. I am here today representing myself and my wife, who have owned a unit at Bayside Villas since 2008. But I am also representing the 102 owners of Bayside Villas as president of the Bayside Villas Condominium Association. I would like to address the specific impacts that the proposed zoning changes will have on the owners and guests of Bayside Villas. The owners of Bayside Villas have serious concerns about any discussions about increases in density beyond what we know is the maximum number of 912 units that can be built within the resort boundaries. Any recommendation to the contrary will have serious consequences to the environment, traffic, and hurricane evacuations, but we understand that these issues have already been discussed by consultants, attorneys, and expert witnesses, so I'll refrain from commenting on those issues. Bayside Villas Condominiums is located near the main entry gate, directly northeast of the South Seas condominiums, and directly adjacent to the resort's South Marina. Our 4,000 building, which is depicted in this slide here to the upper right-hand corner, is about 42 feet away from the property line of the resort's water park, which is under construction. I should mention that Bayside Villas is comprised of two buildings. The 4,000 building to the, next to the marina, and the 5,000 building to the south. The 4,000 building contains 36 units, and the 5,000 building contains 66 units. That's 102 in total. The submission by South Seas, as we understand it, proposes a significant lack of parking for the water park, which is a large and expected high-use facility, as well as for the south end of the resort. Due to the lack of parking available at the water park and at the south end of the resort, and due to some information that we believe has been disseminated that the gate at the main entrance will be removed, and that's a question for the resort. Will the gate be removed? Non-Bayside guests will attempt to use our parking, our amenities, and fishing on our property. The association will be forced to install traffic and pedestrian gates to keep cars, golf carts, and unauthorized people from entering and using our parking and amenities. Also, water park structures appear to be being built right to the property line without any setbacks or buffers. It's a noisy use, and Bayside Villas owners and guests will be negatively impacted without the buffers and the setbacks. So right here, this line here indicates the about approximately 42-foot distance from the corner of our building to the property line at the water park. And from that same location on our building was a photograph taken yesterday, which shows the water park, the property line for that amenity, and you can see that structures are being built within a couple of feet of the property line.
So are you standing or within a condo unit within that Bayside Villas when you took that picture?
That is in a walkway directly outside one of the condominium units. That picture was taken from exactly the point where I took the measurement from our corner of the building to the water park property line.
So the water park is located at the intersection of South Seas Plantation Road and Bayside Marina? Because I see another line diagonal to property that fronts on South Seas Plantation Road.
On the first slide, it's located along South Seas Plantation Road and is kind of perpendicular to Bayside Marina's Road. It's the water park is the large swath of empty land there.
So it's the large cleared portion?
Mm-hmm.
Okay, so now the photo.
And the photo is a picture of that land now under construction.
So I'm looking across the parking lot.
Right.
And then I'm also looking across South Seas Plantation Road in this
Correct,
picture?
correct.
Onto the parcel that's being developed as a water park.
Yeah, the road that you see in the foreground is the Marina Road, and the road that's perpendicular to that is the, I believe that's South Seas Plantation Road.
I see. And the point you're making is that the water park is being constructed up to the right-of-way?
The argument that I'm making that is, yes, it is being built right up against the right-of-way without a buffer or a setback, and given our proximity of 42 feet away from that property line, we fail to understand how the county would have given them a deviation on those buffers when we're so close to that property.
Well, I don't know the answer to that because I'm reviewing deviations as part of this zoning application, but it appears that may be a development order that was issued by the county.
And I understand that this is not related to the planning and zoning application, but
It's a little confusing because we have both things going on at once. We got active development under development orders that have been issued by the county and a pending zoning application on the same property.
Understood, but what I'm leading to is, if you look towards the marina, there's a red line next to our building. That is the property line between our 4,000 building and the marina. And we believe that the marina is also part of the planning and zoning application. And we're concerned that the same deviations that they're allowed to have on the Beach House restaurant at the water park are going to be allowed at the marina. That's our concern.
At the marina.
Right.
And this is the main marina, you said, right?
Right. Excuse me, repeat that question again?
Did you or the person before you describe this as the main marina?
No, this is the south marina, a much smaller marina near the front entry gate.
Near the very entrance of the...
Yes.
Okay, so your point is that insufficient buffering between these uses within...
Correct. So to restate my position or my concern, we are concerned that the same deviation concerning buffers and setbacks will likely be granted between our buildings and the resort marina directly adjacent to us, and those same deviations will impact our owners and guests. We are unsure what structures, activities, and amenities are planned to be built there, and we are extremely concerned about how all this will affect the quality of life of our owners and guests. We simply don't understand how deviations from the regulations concerning setbacks and buffers are allowed when one of the primary requirements of the zoning application is that no adjacent properties be negatively impacted. The majority of our owners, including myself and my wife, when we purchased our units, we did so with the understanding that there could be no more than 912 units constructed within the resort. Our understanding was reinforced when the previous owners presented a preliminary plan in 2015 to reconfigure the existing employee housing and but to build up to 912 unit limit at that location, as well as where the current restaurant at the north end is being constructed. Reconfiguring and building up to the 912 unit limit at that time was not an overly contentious issue, as it was presented and discussed with some transparency. That project obviously never proceeded, and the owner that proposed that project sold to Timbers. Our owners are now very concerned that what is being requested in this zoning application will affect the quality of life and result in gated associations throughout the resort and will have serious implications concerning our property values. Historically, Bayside Villas has had one, possibly two of their units go on the market every year, and I've been there since 2008. Currently, there are 14 units of our 102 units on the market. Clearly, there is concern about what is going on in the resort, and people are trying to bail out. All this being said, one of the most unique and precedent-setting features of Bayside Villas is that when the project was approved and constructed, and it has been confirmed that the building was built in accordance with approved plans by the county, all 102 units were built with what is described as a lockout unit. And to the best of my knowledge, Bayside Villas, our two buildings, are the only buildings within the boundaries of the resort that have lockout units. The lockout unit is a separate hotel at the front of each unit that could be locked off from the rest of the condo, and which had a separate entrance, separate air conditioning, and separate bathroom facilities such that it could be rented out as a separate dwelling unit. This essentially raised the dwelling units at Bayside Villas not from at 102 unit to 204 units. So when this came to the attention of some folks, on September 27th, 1999,
Madam Hearing Examiner, for the record, I'm going to object to the relevancy of something that happened that has nothing to do with this application, and it has to do with their lock-off units being out of compliance, but it doesn't affect this application. It's irrelevant.
Okay, please continue.
I disagree. There was a legal agreement that was put in place on September 9, 2002. The resort sent a letter to each Bayside owner that stated the county had notified the resort the rental of these lockout units was unlawful, and to avoid any enforcement action, we were told to disengage those lockout units and make them part of the condominium unit. If in that enforcement issue, you know, there's 102 lockout units could be considered as hotel units and forced us, the Bayside Villas, forced not to be able to use them, Timber should not be able to say that hotel units are not part of the 912 unit count. In conclusion, if Bayside Villas is prohibited from using these dwelling units, then in timber zoning application, any hotel rooms being proposed which exceed the 912 unit count should not be allowed. Thank you.
Thank you.
I have a few questions, if I could.
Sure.
How many of you know, what percentage of your units within Bayside Villas are in some form of rental program?
Probably a little more than 50%.
Are there any residents, if you know, that are full-time residents in your association?
I can only tell you that I am a full-time resident.
And do you have your own separate association that's responsible for your units in your common area?
Yes, we do.
And are you aware of the fact that the water park has an existing development order and was approved under the step back, buffer, and parking
I'm aware.
requirements of the ADD?
I'm aware.
And so a different set of rules and regulations would be in effect if the zoning is approved?
I understand it.
Okay, thank you.
I may make just one comment about the association. In the previous presentation, you had asked about if we were part of any master association agreement. There is no master association agreement, to my knowledge, in the resort.
Okay, I appreciate that. Can we go to the second picture? I did have a question about that, and I almost
Sure.
forgot. In that picture, it says that it's taken from the third floor of the villas. Is that a habitable floor?
Yes,
How many habitable floors do you have?
we have 3 habitable floors.
Okay, over, I think you said over storage, is that what you said?
Three stories over a parking underneath.
Okay, thank you.
Can I add to that question? We at Bayside Villas, we are aware that the 3 stories is existing non-conforming use.
Thank you.
Thank you.
Marilyn Frederick? Good afternoon.
Good afternoon, Madam Hearing Officer.
Please.
I have a PowerPoint, and I'm not sure I know how to get to it.
All right, well, Adam can help you. And then when you get a chance, state your name for the record.
Okay. My name's Marilyn Frederick. I am a resident at Land's End. I'll find my thing here.
You're a resident at Land's End?
Yes. And what you see there is Land's End Village. It is our home. I'm not only a resident there, we reside there roughly 8 months out of the year. I'm a Florida resident. I vote in Captiva. I'm also the president of the Land's End Village Condominium Association. So often, I put that picture up there because so often a lot of people think that what they see when they see those buildings is South Sea Resort, and the resort owns it. They do not. That's a lot of times the face of a lot of marketing material, but that is Land's End, and it is privately owned by 68 private owners. We've been an owner for 7 years at Land's End. We've been owners for over a decade at Plantation House. We do own 4 weeks there. And I'd like to voice my concerns both privately as an owner and also as the association president.
Okay, hang on a second. When you say Plantation House, is that the name of your building, or is that a different
Oh, I'm
location
sorry.
within the
That's-
resort?
That's a timeshare building on the resort.
But
So-
not in Land's End?
Not in Land's End.
Okay,
My
I underst-
apologies.
I
There's-
understand.
Okay. As private owners, we relied on the Lee Plan for Captiva. We purchased where we did because we felt that we could reasonably rely on decades-old Lee Plan for Captiva. We used to own in Naples, at Breakwaters there. It was also a low-height building, but we saw so many large, tall buildings come around us that we were no longer comfortable in Naples. We wanted to be in Captiva, and we relied on the fact that there could be no more than 912 units, or 912 doors, as they say, total that could exist. That would be 272 allowed the resort, inclusive of hotel doors, and 640 owned by others like us, privately owned people. We relied on the restriction of density and that low use intensity of 3 units per acre. We loved that. We raised our sons in Vermont. That's where we go in the summer. And Vermont, it has a lot of green. It's the Green Mountain State. So it has a lot of open area. We wanted a lot of that open, wild type area. Oddly enough, when people asked us from Vermont, why would you want to live in Florida? All there are high rises and people and traffic and everything else. And I said, not in Captiva. And the more they learned about it, the more they realized too, not in Captiva. We relied on this. We relied on the restriction of the height of roughly 35 feet above grade, 42 feet above sea level, and all the other things that the experts, which I'm not one of, will indicate what the heights are. We just knew that in our romantic minds, I guess, that it was no taller than the tallest palm tree. That's what they always said, so that our views would never be obstructed. And we loved that. We also relied on the historic development pattern of Captiva, the quaintness. Those buildings were gorgeous. They used to be gorgeous, even on the resort before they were torn down. When you entered into Captiva and you saw the little white welcome building, it was nicely done. You felt like you were in the Caribbean. And we really relied on that quaintness to never overdevelop. I'm going to say our community relied on 3 units per acre Lee Plan for Captiva because Captiva is a community. It's a community outside the gates, it's a community inside the gates. South Seas is a multi-owned community of which the resort's a part, just as my association's a part, and Bill's and Tom's and so many others are a part. It's not because we're ruled by a master association, it's because we're ruled by a master mindset of what community is. And we always felt that living where we do. We've got the resort as a minority owner of the 120 acres of the 304 acres of the property there. They're a minority owner. You take that 912 units divided by the 304, that was our 3 units per acre. We thought we were safe. That would be good. But if the county takes away 120 acres and treats them separately, what about us? Now you've got 184 acres, And then you take the 640 privately owned units, divide it by that 184, and suddenly you've got 3.48 units per acre. How does that happen, that we become non-conforming with the plan because of the actions of another? Providing special zoning compliance for one part of the community creates a breach in compliance for the rest of the community, I feel in my heart. And I would hate to set apart a community design to be a part of one another. And I really felt from the time I first saw Captiva, and I first saw Captiva in the very early 70s and fell in love with it before this was even built. I came as a child with my father. We were just taking a drive. And there was this little building, and in this little building was a big table. It had a domed glass thing, diorama, I don't know what they call them, but it had different buildings of, and here's our vision. Here is what is to come. And they expressed all my life the idea that this was to be a community. And it always had been. And I would shudder to think that we'd be torn apart by something like this. You know, everyone relied on restricted height per the LEAP plan for Captiva 2. We cherish our unobstructed views out there in Land's End. We really cherish them. I know that everyone who has a view does cherish them, that no taller than the tallest palm tree really provided that view. And as association president, I could tell you that not only are those views valued, but individuals really take the time every day, and they really express this to me. They'll take the time every day to just look out. They're individuals who love the resort, they love the area. Somehow, it doesn't seem right to only favor one entity in any sort of rezoning, to place buildings that are projected to be 20 feet, I don't know how much taller, but any taller than what exists now is really something that would really be a blight to the views of many individuals, not just from our association standpoint, but many others. And recommending the rezoning, it seems to me, favors the value of real estate of one owner while potentially lowering the value of real estate for others. Just as you've heard from other association presidents that, you know, people are trying to sell their places in some areas because they seem like they're trying to run before things can crash down on them. I just really don't understand why you would allow so many deviations in rezoning that protect the rights and values that many have relied on to favor just the one. And again, they're the minority owner, not just in the amount of acreage they own, but from a money standpoint. You don't want to make it a money standpoint, but let's face it, it's got to be about money that all this wants to happen. You know, the private timeshare, non-timeshare associations are valued at hundreds of millions of dollars more than the $50.38 million the current owners of the resort purchased the area for. And this is taken from the just value of the 2022 Lee County Property Appraiser's Office. The report was run in February of 2024. But you could see of the associations, not the timeshare associations, but the associations throughout the resort, the value of close to $500 million of all those associations. Land's End alone is worth twice the value of what they purchased the resort for. But all this rezoning is seemingly bending over backwards for one small owner and totally disregarding the values, both financially and intrinsically, to the owners It's just ignoring those. It seems to me like the tail keeps on wagging the dog here, and I can't figure it out. Zoning protects property rights and values of everyone. That's the reason they exist. All these deviations and requests to rezone seems very unfair to me. I want to talk about accessibility, parking, and safety, because I think it's very important to know that we've always felt fairly safe on Land's End, but when you add the different things that are being added, I think that you're going to overburden not only the density aspects of things, but the safety of things. I put up the picture of the beach house there because that's something that they've used in their marketing, and you see all the people walking and milling around. And yet I also know you've seen, not in my presentation, but presentations previously, just how big that restaurant really is and how close it is to the road. I'm not sure anyone could even balance on the curbing if they wanted to walk around it once it's done. So this rendering, I know it's not reality. They know it's not reality. I know it's not supposed to be reality. But what's really happening feels unreal to all of us that live there. What about the easement protections for everyone? You know, Land's End is one of the entities entitled to the easement at Sunset Beach. It is our legal access to the Gulf. And roughly 10% of our owners or their families are of limited mobility and rely on easy access of that easement to enjoy the beach. Parking is essential for both able-bodied and disabled users to be able to get there. It's essential. Access is essential, and the only way to access it realistically is if there is parking available. It's good to hear that maybe they'll have more parking than what we've been hearing in the past, because it seems like every sign that you see indicates that the only parking is for South Seas resort guests or South Seas owners in their program. There's no parking available for the rest of us currently, and I had not heard of any parking being available, even though we have a rightful access to it. And as was pointed out, the resort was parking on it just the other day, so they must realize too that parking's vehicle parking is allowed there, but I've not seen where you can really have it. And you could see by the picture that Tom put up just recently that when you park right in front of the restaurant, there's a very narrow path for anything else or anybody else to walk or access the beach. So most definitely, there has to be consideration for additional parking in that area. The feeling is that the resort is intentionally overburdening this easement, and it will make it unsafe at best, and it will make it a powder keg at worst, because quite frankly, at Land's End, we have a number of people that do rent out their units, and by rent, I don't mean for long months at a time, but for 5 nights to 14, a couple of weeks type time. And I've already seen the angst that people have when they feel that there's no place to go and park. You put this many more people on an easement that's overburdened by what the resort has chosen to do, and you're going to see some very unsafe situations, just as tempers flare. And as it relates to accessibility of parking and safety, Sunset Beach isn't the only area left unsafe and inaccessible. This is an overview of Land's End. And you could see the lake, which it's actually a pretty lake. It's much larger than it used to be, but it's pretty. And then there's another lake on this side that never used to exist. I keep hearing that, oh, these lakes always existed. That one never used to be there. That used to be like over here. It was just the sixth hole of the golf course. But not only have they trapped us in by these two lakes, which, okay, all right, you put up lakes, but there's a fence that you can see here that goes all the way around us that has also trapped us in. At the entrance, and you can see a picture of the fence there too, at the entrance to Land's End, can't really see it, but there's some bollards there that they put up so that no one could use the path other than for walking. And you see the Redfish Pass there. That water is a very popular fishing area. So you've got scenarios where we've got more traffic there than Land's End people because you have people coming over there to fish and things. They want to park and whatnot. They start blocking us in because they're parking their golf carts, et cetera. And we're really locked in then because once the front is locked in or blocked up, then we have no other access out. That's our only access. In the event of a fire, there have been times, because we do live out there, there have been times when it's been dry for weeks and the winds start to blow and you really do worry that if a spark catches, there's gonna be a fire, and what's my way out? Now, I'm not an expert in anything really, but you know, I spent 40 years as a public school finance officer and / safety officer for that. I've got just a little certificate on fire safety that you can get to be a fire safety watch, et cetera. When I look at the wind and dry conditions and scenarios, I always think, what's my way out? In the event of a disaster, what's my way out? And I never used to worry because I could always go out the back if the front was blocked, but not anymore. It would be tough for anybody to get out the back now, being fenced in. Continuing with parking and safety, this again is the front of Land's End, our only road. And you can see this road actually goes in front of their golf course, the Clutch. You can see there are no parking signs here. Now, those aren't always there. I don't know if they're going to leave them there or not. There were no parking signs there. They took them down for a while. Now they put them back up.
Can you go to the slide before and orient me on that first picture? Where are you showing? Or maybe it's the one before that where you can show me where that is.
It's right here. So this
So
is
that
our
like on
road
the
in.
top of the island there? Is this located
Oh,
at
you
the
mean
top?
where all of
Yeah.
Land's End is? Yeah, we're at the very north tip of the island.
Right, but where is that picture on this picture of all of Land's End?
This image above,
Where's that? It's right there, right? Right where access?
where the access road is from the picture above. Okay, so you're following the road right here.
Yep.
So that's going into Land's End.
Okay, so the first picture on the next page is at that intersection there?
Yes. Yeah, that's our only way in. It meanders past their golf course and past Seabreeze and then into ours. There's a pretty severe curve there.
So where are the bollards you spoke of in this photo?
Well, the bollards are on the path. There were there's a walking path that used to be a golf cart path also. People used it quite frequently. Every night at sunset, people would, I'm losing my thing here. People would take walks, bicycles, and golf carts around this path to go to the very end I call this little out thing North Point. I don't know if it really has a real name, but they would go out to this area, and they would not go onto the sandy beach. I've heard many times that they blocked all this off because we don't want golf carts driving on the beach. Have you ever seen a golf cart on a beach? Because it sinks. Your typical golf cart can't drive on the sandy beach unless it's pretty rock hard. You could get probably an ATV out there, but the golf carts that used to always use this would park probably in that green area there, or they would just sit in their golf carts, watch the sunset, and then they would drive away either that way or come back the other way to enjoy things. But that's basically where they would go. Well, they put up bollards here, so that way no golf carts can go there anymore. People could still walk through there. However, I have witnessed a wheelchair being unable to get through there, and the parents of a girl in a wheelchair lifting her out, the other folding the wheelchair to be able to push it through the bollards so that she could go on a walk with the family. They have not made this very family-friendly for a lot of different people. Is that everything you wanted on that page?
Yeah, you
Okay.
can go back to the next page.
Okay.
I just was trying to get located.
All right. I know there's a lot thrown at you. I'm amazed at you. I don't know how you do it all, but, so this is still the road going into Land's End. They've got that no parking up. They've got this vehicle parked there. Now, this is a very narrow area. It's a curve, and when I went to ask the vehicle to move, I was told that he was told by the security guard to park there because he was setting up for a wedding up here. Oh, I'm sorry, you could even see the security truck as I was talking to the guy, he came over. So I said, well, why didn't you park at the golf course? They don't have any parking at the golf course, but they do have a semicircle that you could drop off people. And he said, well, I didn't want to block their golf course. I'm like, oh, okay. But you don't mind blocking our drive. And you can see in the second photo, this is a golf cart coming out of Land's End who's totally stuck because she has to wait for the traffic to come around. And, you know, it's only a few minutes, but hey, it doesn't make sense to me that you would have no parking there. You would allow vehicles to park on the road, a road that can't be wide enough to allow that, and restrict the flow of traffic like they do. There's a couple of cars behind them, so it took the golf cart a while to move. This was further back, by longer ago, where the same scenario happened. Now, they were actually putting in some sort of wells on the golf course. I don't know what exactly that is, but that came about and blocked me as I think I might have been coming back from the farmer's market, but I was coming back and it blocked me for 40 minutes. I couldn't get home. We didn't know this was going to go on.
So the entrance to the community is in front of that truck there?
Yeah.
You're saying?
Yeah, it's right there. So they had many trucks blocking us, but that one was the one that really, it took up a lot of space. And then they turned around in Land's End, going over our curbs and breaking a couple of irrigation heads that I didn't even bother asking. I mean, the resort, if something is damaged on Land's End because of the vehicles that have gone in there, the resort is good about fixing them, et cetera. They understand that. But I just do not have an understanding of why we're never made aware when there's going to be major things like that happening. That would be a courtesy of any neighbor. We're not made aware if there's going to be a wedding happening up here, which would cause, you know, any sort of blockage. We're just always, I'd want to say we're an afterthought, but we're not even a thought. it's not a good community aspect. And again, here's another cart that was just sitting there. They didn't go on our property, but they parked there because, of course, they want to go fishing on Redfish Pass. That's one of their carts, and they just park anywhere. Here's another one that actually did go on our property, and we had just newly smoothed this out to put on landscaping, and we have to smooth it out again because this was Sunday, they went over, they parked there, they went out. What they'll do is they'll park and then they go across to, they go under our buildings to access the pass. So it's just one of those things that I know that we're always going to have parking issues, and we're going to now have to police that. We've already begun policing that. It's bad enough with the traffic that we had. Even as we drove here today, traffic going onto the island was backed up, almost a shell point. There's a lot of traffic as you leave the island. You have pedestrian, you know how narrow the roads are. We had to slam on our brakes as a bicyclist was coming across in a place that he shouldn't have been coming across. There's strollers on your other side. Really, I love seeing families, but when it comes to those double strollers, you know, they really take up a lot of space. So you're constantly being on the defensive as you're driving. There's no way that you are not being 100% focused when you drive on Captiva close to the resort, because there's lots of people walking with no place to walk. There's lots of bicyclists with no separate bike path, and a lot of times cars can't make it through. So this is at a time when there's hardly anyone on the resort, so to speak, because they don't have any of their hotels or condos up. I can't imagine with 628 units how many vehicles and how many more people that will congest our roads with. Honestly, I can't imagine it, and it's scary. You know, before, there were 107 hotel units, and when full, there were no extra spaces in their parking areas. I know because I lived there. I would often go and just take a bike ride through, and when it was busy, it was busy. There were 140 employee housing units, and it seemed to always have some space there for parking, because I don't think all of them had cars. I think it was just a small percentage. And there are 25 undeveloped units, so there weren't any cars there. But rent, after they get all these units in, renters bring vehicle. They bring vehicles, and will there be 628? No, I think there's going to be more than that, quite honestly, because I could tell you at Land's End, sometimes I call myself a bottom dweller. I'm on a lower unit, and then the larger units are above us. So each building at Land's End has two bedroom units on the first level above parking, and then they have 2 3-bedroom units on top of us. So I know when people come in, they rent, and I know because I can hear them. And I also can hear any sort of issues if they're having issues parking. So my experience living beneath a rental is they bring vehicles. And I'll tell you that a 2-bedroom unit always has at least one vehicle. I know what's coming and going. They always have at least one vehicle. I've never seen them just come without one. And the 3-bedroom units almost always have 2 or 3 vehicles. And why? Well, they consist of more than one family a lot of times. If it is just one family, often it is only 2 vehicles. They come in a car, they rent a golf cart, and they park underneath our buildings. We can accommodate that. When it's 2 families, or maybe 3 friends, 3 different couples, they each bring a vehicle. We can't accommodate that. So, and I know this last week, we had one Ram 2500 pickup truck, one Wagoneer, one very large other vehicle, and a golf cart for one rental unit above us. And I went down and I said, you know, I'm sorry, but are all you parking here? And they said, well, it looks like you don't have room. And I said, yeah, it's true. You know, I think I can give you the one parking space because we realize you're renting that unit and they have a parking space, and we can accommodate the golf cart, but everybody, you know, everything else is full. So what they did was they called up Marina, who's the owner's relations manager at the resort, and she found them another place to park. And I believe they told me, oh, this is good, we'll park the pickup at the marina. So I think it's more realistic to believe that people who rent to stay for a week or longer at these places are going to come with a vehicle. I think it's very unrealistic to believe, in my experience, just living there as I do, that people are not going to come with vehicles. They'll need more parking. So, Madam Hearing Officer, thank you for listening. And I want to ask you to please advise the board to honor the agreement they made with this community that we have relied upon for decades, and certainly since 2003. Please advise the board to uphold the same density, height, and intensity rules that we have all legally relied upon. And please do not relieve the applicant of the burdens of their own making by placing unsafe, unsightly, and unfair burdens on us. Please advise the denial of the rezoning of the 120-plus acres from residential multifamily, marine commercial, and two-family conservation to the mixed-use plan development to permit a maximum of 196 multiple-family dwellings and 435 unit hotel units with accessory uses and structures. That's not what Captiva's about, and we can't handle it. Thank you.
Thank you.
I have a few questions.
Just a sec, Neil, just a second. Do you have a paper copy of the PDF file that you?
I do, and one of the other things I wanted to mention when I was talking about I was an owner and president of the association, I'm also a CCA member. I also use the library and, you know, multiple other community memberships and activities. So I feel like
Okay, so this is Marilyn Frederick, Composite Exhibit 1.
Thank you. Appreciate it.
The next name I have is
Wait.
Leo.
Oh, wait, you had a question.
Oh, I'm sorry.
Sorry.
I'm moving forward. Sorry about that.
Can you go back to your PowerPoint? Is that still possible, or did it disappear?
I don't know. Okay.
Well, Adam's there to help her.
I'm up here.
She can't.
It might have disappeared.
There we go.
Okay. Yeah, let's just go to slide 1. I think that's helpful,
Okay.
if we can.
Yes.
Okay. So you represent Land's End. So when you talk about what Land's End is, how big is the area and how many units do you have?
We have 68 units. There's 17 buildings and one small building that's an office pool area building. There's some playing courts that you could see there. And the property line, there's another person who will be speaking more to the property lines, Leo Fahrenkopf, who's also a resident there. He has more information on the property lines.
Okay, so he can tell me what the acreage is?
I'm not sure if he'll know what the acreage is of that, but he'll know what the property line is.
Okay. How many floors, if you know, are all those buildings?
There's the very first floor is parking, which is 76 to 78 inches high. It's very low. As a matter of fact, one of the South Seas golf carts just Sunday broke one of our fire sprinkler pipes, yeah. Your security is very good, they called the fire, everything. Your employees work with us so often on those type of things.
I appreciate
but
that.
It's very low. And then there's two then there's the first floor would have the 2-bedroom units, the next floor has the 3-bedroom units with one of the bedrooms on what you see is almost like a little penthouse little area.
Okay, so the second habitable floor has sort of like a mezzanine, is that what or a loft, or what would you call that?
It's, see how it's not a full floor, it's got a bedroom up there and a bathroom, and there's a lot of wraparound porch, so to speak, up there.
Okay. So the property, and I know you have the other gentleman coming, the property between you and the water then is golf course or property under the ownership of South Seas?
Yeah, so our property line does go only, I don't know how many feet out from those buildings, but that golf course hole that used to be the 6th hole, it's now a lake, that's all resort property.
Okay. Now, it's my understanding that during Ian and perhaps Milton, that there was an overwash there which damaged what I'm going to call the riprap revetment area. Is my understanding correct?
Yeah, primarily Milton, it seemed, did more damage almost than Ian when it came with that. The surge did come up. It pushed a lot of the stones around, some trees. It is one of our concerns, most definitely, too, because of that large lake you saw on the other side where there has always been a lake there, but it's much larger now. We're almost a little worried that if there is another major surge like that, that will become like North Captiva and cut off from the rest of Captiva. We'll be kind of like Middle Earth. It'll be middle Captiva.
Okay, but since the storm, it's my understanding that extensive work has been done and that revetment has been repaired and enhanced. Is that?
No. I mean, there's been some work done. I think after Ian, there was extensive work done.
And maybe that's what I'm thinking.
Yeah, I think that's it. It hasn't been totally repaired yet since Milton. I'm sure Sean knows better what the timeline is and what the hurdles are on that. But no, it's in pretty bad shape right now. It's in really bad shape. And the lake that you've built there never seemed to really hold water right.
The old lake, not the new lake.
The new lake. The new lake on the 6th hole. It really suffered damage. And it never quite held the water like it used to. And I only say that because they seemed to rebuild it a number of times. They did the other lake too, but this one's in bad shape. I don't know what's going to happen. I don't know what the future is of it.
Okay.
It doesn't seem to hold the water is what I'm saying.
So your buildings are higher than what the current ADD allows. Are you aware of that?
I believe in listening to what David Mintz had said earlier, that we would be within that base sea level, flood wall, et cetera. And I think a person coming behind me would probably know best on that too.
Okay. You talked about nonconformity and the 304 acres. Were you aware that 97 acres was conveyed away to the Department of the Interior and is not part of the resort at this juncture?
You know, I was aware of that, but because it's the Department of the Interior, U.S. government owning it, it still provided me with that concept of green space. At least in Vermont, we call it green space. I don't know what it's called here, but I think it still has that effect, that you're not going to build on it, and it's open.
Absolutely, you're absolutely right. It's going to be there. It's got a conservation easement on it, but you can't count that somebody else's property towards your density. Does that make sense?
I understand what you're saying, yeah.
So the land end was over the 3 units an acre once the 97 acres was conveyed away to the Department of Interior. So it was a series of events, that conveyance as well as the adoption in 1984 of the comprehensive plan that had a density limit based on the land use category.
Yeah, from that standpoint, technically, I'm sure you are correct. However, from the standpoint of its general purpose, the idea of why there was just 3 units per acre, I think it still lives up to it because of that open space.
Okay.
And that's the beauty of what we have on Captiva. That's what we enjoy about it.
And you made a statement, and I may have misunderstood it, that the county would be taking away the 120 acres, or your right to use the 120 acres. Does land then have any ownership interest in the 120 acres that's the subject of this application?
We have easements, but we don't have ownership.
Okay.
Is that it?
I got a lot of notes. Can you wait just a second? On the road to land then, how much of that do you maintain and how much of that does the resort maintain, if you know?
Again, the gentleman coming behind me will talk more to the road and the entrance, but we maintain most definitely everything that is, there's black asphalt that, actually we still maintain a little bit of that too, but there's the black asphalt, and then you'll also see red bricks, and we maintain all the red bricks.
Okay.
There's a time earlier where the resort was pulling up the red bricks, and we gave Sean a call, and we said, well, you're pulling up our bricks, and he had them replace it. But yes, we maintain all that. It's really interesting because the property lines cut in a variety of ways, and while we might have those little red bricks, there's a little white retaining wall that the resort has, and they would maintain that. So when their truck hit it, that big one I showed you, when they hit it, then they did repair that and repainted it. Since then, another truck's hit it. But so we're such an integrated community. That's why it's so hard to understand how any part of us can be taken away from each other, because it was clearly designed to work together and not against each other.
You indicated that the unit over top of you is a rental unit. Do you know what percentage of the units in Land's End are rental units?
I think there's roughly, with the resort, about 28%, and throughout the rest of the Land's End, about 40% of them rent.
So either privately or through different rental management
Correct. They
companies?
use Royal Shell, Dream Vacate. There's a variety of them.
Okay.
But I think at one time, the resort had all the rentals, and now they're down to about 26%.
Okay, so 26, and what's the other percentage, 40-some percent?
40% of all the 68 units are rented that we know of right now. It's gotten as high as closer to 50% that I'm aware of. But since the storm, some of those places have wanted to take the opportunity to do some renovations internally, so they haven't opened them up to rentals yet.
Okay.
Although they are open to rentals, but some of those owners decided not to rent yet.
So you're a 9-month of the year person. How many other, if you know, what percentage are actual residents that live here long enough to?
I don't know the exact percentage. I know that there are a few of us on there. There's a gentleman whose wife is in a nursing home down here. He lives here virtually year-round. Certainly, there's Leo, who will speak today also. He's a resident of Land's End, and there are a couple others that might also be, but it's not a question we normally ask people.
Yeah, so, understand. But it's fair to say it's a rental community and you have visitors and tourists on a regular basis at Land's End.
Yeah, I think the majority are probably not renting, but there are like that 40%, as I said, that do rent out their spaces. And that varies. Some of them only want to rent it out very rarely, and others do it quite often.
Okay, all right, thank you.
You bet. Thank you very much. Thank you all.
Thank you. We're going to take a break now for the court reporter. We're going to quit for the day at 4, but the next speaker is going to be Leo Fahrenkopf. I hope I pronounced your name right. When we resume, it'll be your turn to speak. If you do not finish before 4 o'clock, we will start with you the remainder of your presentation tomorrow morning. So we're going to take a 5-minute break right now. Wake up.
Thank you. Good afternoon, Madam Hearing Examiner. My name is Chauncey Goss. I'm speaking in my capacity as a resident of Sanibel. I live at 978 Oyster Court with my wife.
978 what?
Oyster Court? Got it? I'll slow down. I have a tendency to speak
I'm sorry,
fast.
I didn't catch your name. Can you say it again?
His
First
name
I-
is Chauncey Goss.
Oh.
He is a resident of Sanibel.
Oh, I know who he is now that I know.
It's Montgomery. My wife and I have lived there for 15 years. We've owned that house. I had the opportunity to grow up on Sanibel Island. My family moved there in 1971. And over the last 54 years, we've watched as traffic has slowed to a standstill on our evacuation routes, as sea level has impacted both storm surge and groundwater levels, as water quality has been degraded by septic tank and treatment plant failures, and as climate change has provided more intense direct rainfall. Now, we moved to Sanibel with the full understanding that it's a coastal high-hazard area. Part of the reason my father worked so hard on Sanibel's incorporation back in 1974, and part of the reason he worked so hard on developing the Sanibel Comprehensive Land Use Plan, which is known worldwide as an incredible plan, was because he understood that hazard, and he understood that the quality of life could only be met if we had appropriate density. He understood that sometimes quality trumps quantity. So by setting realistic density targets, Sanibel has really flourished these last 50 years, as has Captiva. I think Sanibel was recently voted one of the best beach towns in the country, if not the world. And that's not by mistake, that's by design. So the original developers of South Seas Plantation, Mariner, understood that as well, and it's for that reason they didn't seek to maximize density when it was first developed in the early 70s. They settled on a 912 unit, inclusive of hotel rooms, and that number was further agreed by Lee County in a three-way settlement with the residents of Captiva and the resort's owner in 2003. And I don't know if the Timbers Group understood those limitations when they purchased South Seas. Given the quality of the experts they've hired, I'd be very surprised if they did not. In the spring of 2022, right before the hurricane, their new ownership invited me up to tour the property with them. And when the tour was over,
Just slow down, I'm having trouble following you.
Yeah, so spring of 2022, right before Hurricane Ian, got it? The new ownership, they invited me to tour the property with them. And when the tour was over, we had a parking lot conversation, like you sometimes do after you've had a tour. And Mr. Spencer said they didn't plan on, I asked him two questions. I said, do you plan on increasing density? And he said, absolutely not. And I said, do you plan on working with the Captiva Community Panel or the Captiva Civic Association? And his answer to that one surprised me a little bit. Mr. Spencer said, I don't have to work with them, and I don't have to work with the residents of Captiva, because all I need is 3 votes from the Board of County Commissioners. In my former life, prior in my career, I worked as the executive director of something called the Gasparilla Island Conservation and Improvement Association, which is also known as the GICIA, and that's a property owners association on Boca Grande. And when I worked up there, I worked very closely with the development community on issues. They were important to the island. It's an island not unlike Captiva, and it's unincorporated Lee County. Now, we didn't always agree with the developers, but ultimately, the product was always better after we received input from the community. So I was surprised to learn that Timbers would sort of throw down the gauntlet and try and steamroll this project through by focusing on its lobbying efforts in this building rather than developing community consensus on Captiva. This strikes me as cronyism at its absolute worst and poor governance at its absolute best. After Hurricane Ian, the applicant decided to cloak its request for a density increase as resilience, and further began using a definition of density that's really more a term of art than a definition that meets the reasonable man standard. How could squeezing more people into a high-hazard area be anyone's definition of either resilient or anyone's definition of a reduction in density? I've listened to some of the testimony given by witnesses, and I'm struggling to understand something. And I don't do this for a living, so I'm just a resident of Sanibel trying to figure this all out. So why are we allowing the applicant to argue anything other than a binary when it comes to bringing more people to a high-hazard zone? So the question should be simply yes or no. It shouldn't be a question of degree. So does this rezoning put more people in harm's way during a natural disaster? And the answer is yes. Does this rezoning increase traffic and slow evacuation times? The answer is yes. Does this rezoning place a greater burden on an already stressed wastewater plant? The answer is yes. So once those questions have been answered, why are we spending so much time on them? Why spend time figuring out how many more people are going to die in a storm? Because I can't believe the LEAP plan has a section on risk stating that if only 10 more people die, we'll approve the rezoning. The acceptable level has to be 0. The applicant can't prove 0 if the applicant can't prove 0, or that their plan improves the situation by removing people from the high hazard zone. Then the answer from the county has to be no. Why argue it about how long it takes to get to Jacksonville when we're talking about traffic, when the simple truth is putting more cars on Captiva, it's going to slow evacuation times? Who really cares by how much? If it's 1 second more, it's too much. If it's one more life, it's too many. Again, I can't believe the LEAP plan envisions any slowing of traffic in an evacuation zone in a high hazard area as acceptable when reviewing a rezoning. If the rezoning exacerbates already bad conditions, how can it be approved? So in closing, I'd like to say the applicant is incredibly talented. They're a very good developer. They've pulled together a really dream team of consultants, engineers, land use advisors, one of my favorite attorneys. With a little creativity, a commitment to intelligent recovery, there's no reason South Seas couldn't build back at its long-approved density while really being the poster child for Barrier Island resilience. Thanks.
Thank you. Next speaker. Oh, Mr. Goss?
Yes.
If you were basically reading from your notes, would you object to giving it to the court reporter? You don't have to enter it into an exhibit, but you were a very fast speaker, and it'll be helpful to her. Tony Lappy. Good afternoon.
Good afternoon. For the record, thank you for hearing me, Madam Hearing Officer. My name is Tony Lappy. I own and operate Tween Waters Inn. I live on Sanibel, but have worked both day and night on Captiva since 1976. That'd be 49 years. The same property. I'm also a board member of the Captiva Community Panel, and I'm also on the board of the Captiva Island Historical Society. I don't want to be here, but I need to be here. I have always had great relations with South Seas in the past. As of now, they have never reached out to me to say hello. I guess that's the difference between a developer and an innkeeper. I really want them to reopen. For those of you who remember, after Hurricane Charlie in 2004, it took 2 years for South Seas to reopen. That hurt our community. We want them to reopen, but we want them to play by the rules. People always ask me over the years, how has Captiva changed? The small houses got bigger, but nothing else has changed. It's still the same place. I have guests that have been coming to my inn for over 40 years, and they love Captiva the way it is. They say, yeah, it's changed, some of the houses bigger. But in my relations with the community, I've never seen the community pull together as much as they have against this particular situation. Following the rules. I did it years ago when we asked the Civic Association, could we knock down employee housing and build units accordingly? We went through the process, we followed the rules, they allowed us to do that. Royal Shell did it with Jensen's Twin Palms Marina. My hats are off to them. South Seas will automatically get an increase in density by knocking down the 140 units of employee housing and being able to rebuild those units, not as small units, but probably maybe a 2-bedroom or something. Has that been granted? I don't know, but I think it's in the works, and I have no problem with that. Matter of fact, the Civic Association or the CCP, I think, was agreeable to look at those things. There to me lies some middle ground maybe that could be established. In closing, rezoning, what is rezoning? Rezoning is changing the rules. And it's okay to change the rules if you have enough people that agree upon it, a vast majority. It happens all the time. But in this situation, in everything I've heard, there's only one entity that wants to change the rules, and everybody else is against it. Thank you for your time, Madam Chair.
Thank you, Mr. Lappy.
Can I ask a few questions?
Sure.
Thank you. There are billboards that suggest that Twin Waters has day passes. Do you have day passes that allow people to park and use all your amenities?
We limit it based on the occupancy.
Of,
And you might be thinking of Sundial, because I don't believe it's on our billboard.
but you do have day passes.
Yes, we do.
And when did you first start with Twin Waters?
1976 in October.
Well, I know you said 76, but I wasn't sure if you did something else initially.
No, I came down, I had 3 employees when I started. A lot of fun.
So, in looking at aerials, it appears that you have added buildings and uses and units over time.
Good point. When we bought the property, we had water rights when we bought the property in 1970, which gave us the ability to rebuild. Those water permits at that time were in the moratorium. They were not issuing any, but we were already allowed to build those.
So how many buildings and units have you added since, if you know, since 1976?
Sure. We started with 47 cottages. We now have 137 units.
And how many buildings?
How many buildings?
Yes, sir.
2-story buildings or cottages? What do you mean buildings? Be more specific.
Okay, how many do you have in the 2-story building along the road?
32 units.
And have you added restaurants over time?
Yes.
How many restaurants do you have?
I have a total of 3.
And do you have retail, like little shops?
Little shops. We have a marina that sells clothing at the same place. It's
Okay.
been there. It's matter of fact, I think it's on the historic register. And just so you understand that historic register, we wanted to be on the historic register, so I went out and got that deal.
I appreciate that. And so how many slips do you have, wet slips available to the public?
Depends
or
the
to-
size of the boat.
Pardon me?
Depends the size of the boat.
Okay. What's the range from how many to how many?
You could probably put 20 boats.
And do you lease golf carts that people can drive around?
Do I
the island?
lease them? No, I do not.
Do you work with someone who does?
No, we have no commissions or anything involved.
Okay, thank you.
Richard Levinson, please.
Good afternoon.
Good afternoon. Thank you for coming.
Thank you for hearing me. My name is Richard Levinson. I live at 16201 Captiva Drive. I'm a member of the CCA. My house is about a mile from the gates of South Seas. I'm a Florida resident and a Florida voter. I first visited South Seas with my family in 1987. In 1994, we purchased a condominium there that we owned until 2011 when we moved to our current house. I'm a board member of the Ding Darling Wildlife Society, and that's the Friends group that supports the wildlife refuge. It's managed by Fish and Wildlife Service, U.S. Fish and Wildlife Service. I have a bachelor's degree in economics and mathematics and a master's degree in quantitative methods from Union College in upstate New York. I also have a master's degree in finance from the Wharton School of the University of Pennsylvania, where I was a doctoral fellow and an adjunct faculty member. I held planning and analysis positions in the New York State Governor's Office during the New York City and New York State financial crises in the 1970s. I served as Deputy Secretary of Revenue for Policy and Planning for the Commonwealth of Pennsylvania. And then I worked in the Federal Reserve System for a while. And my major longest-term employment was from 1983 to 2000. I worked at what was then called Citibank, and I was responsible for managing the balance sheet, which was about $250 billion spread across 60 currencies and countries.
Spread across what?
60 different currencies and countries. In 2000, I left Citibank and I started my own investment and consulting firm in New York City, and I'm still involved in that. The common themes of my professional experience are planning, modeling, management, and analysis of complex systems. I taught at several universities and gave seminars in the US and abroad on these topics. Generally, the objective of this discipline is to understand how things work in the real world. The most common approach to doing this is to create a computer model, make a whole series of assumptions, feed them into the model, test the model under different conditions and scenarios. I believe that most, if not all, of the expert witnesses that the applicant presented employed this sort of methodology and approach. I want to emphasize I've not had the opportunity to review the expert's technical analysis. I'm not a subject matter expert in many of the fields that they talked about. What I do have is methodological expertise, and I listened very closely to the testimony that was presented. In that process, and based on my experience, a number of questions occurred to me that I consider important. I believe that very real problems have been ignored or dismissed by the applicant's experts, and it's critically important that these issues be addressed. I'm going to attempt to run through a few of them without belaboring this process too much. A very important issue is the resort's capacity to handle sewage and wastewater treatment. The proposed development will increase the use of the resort by 40% and will have at least a concomitant increase in the usage of the generation of wastewater and sewage. Again, I'm not an expert in this field, but I do know from the 24 years that I spent at the resort that sewage treatment was a chronic problem, and from time to time, big tanker trucks had to be brought in to haul the effluent away. I also know that the Captiva Community Panel conducted a study of the FGUA plan as a potential solution to Captiva's wastewater problem. That was rejected as not feasible. With this, I was very interested to hear the presentation on the applicant's sewage wastewater treatment expert. But that scheduled testimony was canceled at the last minute and never rescheduled. Are we truly going to approve a 40% increase in dwelling units without a clear understanding of how the past problems have been corrected and how the capacity to serve the increased demand will be created? Is it feasible to meet that need within the existing footprint of the FGUA plant, or is the increased density going to be used as justification to expand that plant into the tidal mangroves, which would be a violation of the Lee County plan? These are absolutely critical issues, and this application shouldn't proceed without a full public disclosure of a credible sewage and wastewater treatment plant and any required incursion into the mangroves. The applicant's presentations regarding traffic and parking also require critical review. The existing condominium and timeshare units have concerns about safety and parking within the resort, as we've heard from a number of people today. The community outside the gates is concerned about the traffic on Captiva Drive. Plantation Road is a constrained 3-mile road that travels more than 3 miles through the resort. The applicant owns some of the segments of the road. The condominium association owns others. This road is constantly and heavily used by cars, service vehicles, the resort trolley, joggers, and cyclists. At an earlier point, there was testimony regarding the posted 19-mile-an-hour speed limit on that road. And there was a lot of discussion about how that seemed to be an odd number. That sounds protective, but there's no enforcement of any sort on that road. The resort staff does not have police powers, and the county sheriff, because it's private property, typically enters only when called. In the 24 years I spent at the resort, I never saw a resort staff or a Lee County deputy cite somebody for unsafe driving or excess speed. However, on my daily walks and bike rides through the resorts, I had a number of close calls from cars that were speeding and golf carts being driven recklessly by underage kids. If we are going to, the safety enforcement there, the 19 miles sounds protective, but it's just words on a sign that anybody is free to ignore, and a lot of people do. If we are going to approve this, the applicant needs to credibly describe how a 40% increase in the density of the resort with no improvements or expansion to the roads is not going to create or compound safety issues that are already exist on Plantation Road. The applicant expert also testified that there'll be minimal traffic impact on Sanibel or Captiva because the resort will be self-contained and guests won't need to leave. Let's explore that for a minute. If the development request is approved, there'll be 1,268 units at the resort, not counting the private homes that are already there. The resort has chosen to cluster 4 restaurants: Beach House, Harborside, Redfish Grill, and Scoops and Slices, within a few hundred yards of each other at the north end of the resort. This is a far distance from where the planned hotel and development on the site of the previous employee housing was. It's a good distance from many of the other condominium developments along the road. The Beach House restaurant, as you've seen, is adjacent to the main path to the beach, Sunset Beach, and the planned spa is going to be located right across from the Beach House restaurant. A little further north is Redfish Grill and Scoops and Slices, which are part of a big pool complex that already exists. And then around the corner and further down is the bag drop for the golf course. Clearly, this is going to be a very busy area during the day. Let's take a moment and think about what happens at high season. The resort is 90, 95, possibly even 100% occupied. And let's assume there are 2 to 3 people per unit. With that set of assumptions, between 5 and 8 o'clock every day, something like 2,000 to 3,000 people are going to be looking for dinner. They're going to be hungry. Now, some of them will stay in their units. Some of them might walk to the restaurants. Some of them may take the trolley. But given given that level of occupancy and given history, the restaurants will be full. There'll be long queues to get into them. There are going to be, in that scenario, several hundred cars and golf carts converging on that section of the resort looking for parking. And I don't know for sure, but I suspect the spa may also be may be operating during that period. The residents of the private condominiums in that area are very rightly concerned that with this level of traffic coming to that area every night, there's going to be serious traffic problems and parking problems. There will not be parking capable of handling that kind of demand. And so the people are going to be forced to park in fire lanes, park in the private spaces of the condominium associations, or do something else. I think if we're going to go forward with this, and the restaurants are already either built or in place, I think we need to take a very, very careful look at what happens at a peak period during a peak season of occupancy. The whole question of employee parking and commuting was glossed over in these presentations. As I understand, there's planned to have 800 employees at the resort, and we've heard there's going to be vans to ferry them back and forth from their homes. It's interesting that if you look at the careers section On the website of the applicant, there's about 40 different categories of jobs posted. If you click on any one of them, what pops up under benefits is company-paid toll programs. By offering this benefit, the applicant not only recognizes that the van programs won't serve all of their employees, but they're actually creating an incentive for their employees to use their own cars to commute. Now let's just, again, do a little bit of back-of-the-envelope calculation. Let's say the van program attracts 60% of the employees, which would be very high for a program like that. If that's the case, there could be a need for 200 to 300 parking spaces at the resort for the employees. The city of Sanibel's website says that there's heavy traffic onto the island every day from 8 to noon and every day exiting the island from 2:30 to 6:30 p.m. Waiting time and traffic to get onto the island, to get through the island, or get off the island at these times can easily exceed an hour. If the South Seas employees commute during this time, and many of them will, they will be adding scores, if not hundreds of cars to this congestion. It's hard to square all these facts with the applicant's assertion that employee commuting will create neither traffic nor parking problems. What's interesting is that the resort has offered a van program for years. As such, they should have real-world hard data on how many of their employees use their vans and how many of them commute. From that real-life hard data, they could have made serious, respectable presentation on how much traffic the employees would create. They may have done that, but it wasn't presented to us, and I think we need to see that and understand that as part of this, because 800 employees, none of whom will be staying at the resort, and all of whom will be commuting every day in and out of the resort, is going to create some sort of a burden. We can't just wave it away and say, don't worry, there's going to be a van program. It just doesn't make sense. A further concern that I had is the conflict between the applicant's traffic and economic analysis. As previously stated, the applicant's traffic expert testified that the resort will be self-contained and guests will not need to leave the grounds. A short time later, the applicant's economic expert testified that the proposed development would be an economic boon to Captiva and Sanibel. Both of those statements can't be true at the same time.
Say that again?
The traffic expert said the resort is self-contained, people won't need to leave. The economic expert said it's going to be a great boon to Sanibel and Captiva. Both of those can't be true at the same time. If people stay on the resort, there's not going to be an economic boon to Sanibel and Captiva. If people leave the resort, there's going to be traffic, and there's going to be a burden that's got to be analyzed and understood. We should not allow this conflicting testimony to stand. As I've described, the applicant's representations regarding traffic and parking and economic benefits have big gaps and they're very inconsistent. With a project of this scope and its impact on the community, the applicant should be required to provide comprehensive, credible, and internally consistent analyses of these issues. I'd like to take just 1 or 2 minutes to talk about evacuation, which some other people have talked about. I'd like to put maybe a slightly different perspective on it. We heard one of the applicant's experts describe a scenario in which a hurricane occurs at a period of low occupancy and with 2 days' notice. People are assumed to evacuate in an orderly fashion down Captiva Drive and Sanibel Captiva Road and Periwinkle Place, all of which are constrained 2-lane highways, and then go over the causeway. And once they're there, they're on on Summerlin, which has been improved, and then it's an easy shot to 75, where they can proceed nicely and safely to a safer environment. We really need to do some reality checks and some stress testing here. Due to the successful efforts of the county's tourism group, and I believe the applicant participates in this, summer tourism in Sanibel and Captiva, summer and autumn tourism, is growing. These are heavily in-state people who come by car. We are also experiencing earlier and more frequent hurricanes. So the assumption that a hurricane is going to occur at a period of low occupancy is really suspect. In his testimony earlier, Ken Suarez described a hurricane that was 200 miles offshore and did not motivate any evacuation orders, but it caused great damage in our area. In 2022, Hurricane Ian's path was very uncertain. Until very late in the storm's development, projections were that landfall was going to be in Tampa. The path was so erratic that evacuation orders in Lee County weren't issued until a couple of hours before the storm slammed into Captiva, Sanibel, Fort Myers Beach, and the surrounding area. Ultimately, 54 people in Lee County died in this storm, and the lack of warning was cited as a major factor in these deaths. So the assumption that there's going to be 2 days' notice that will allow people to efficiently and orderly evacuate is hard to accept. Let's leave it at that. We also know from recent experience that the assumed orderly evacuation on this route is very suspect. A simple web search of Hurricane Ian or Milton evacuation, a simple web search of Hurricane Ian or Milton evacuation traffic will bring up many links and videos describing gridlock on I-75 and the tributary roads. So any suggestion that an orderly exit off the island once you're over the causeway is also suspect. More fundamentally, all of our discussion has been on hurricanes so far. But a hurricane is by no means the only problem and risk that we face. Madam Examiner, you said you've driven out to the site, so you must have driven down Sanibel Captiva Road. If you did, you noticed on the right side 3, 4, 5 miles of vacant land and almost as much on the left side. The land on the right is part of the Ding-Darling Wildlife Preserve. The land on the left is owned by the Sanibel Captiva Conservation Foundation. You probably saw miles of dead trees, and back from the road, there are acres and tons of debris and branches and fallen trees. A lightning strike, a carelessly tossed cigarette, a downed power line, a truck driving off the road with a drunk driver is all that would be needed to start a fire there. And if a fire started there, it would spread very quickly and would likely jump the road. And there would be very high heat because there's so much tinder in supply there, and there would be a lot of smoke and very limited visibility. What would happen in that circumstance is that firefighters and other first responders would converge on Sanibel Captiva Road, and their trucks would clog the road up and down and constrict traffic flow. That's the sole exit from Captiva and the west end of Sanibel. The January reports of fires we all saw from California show what it's like, a graphic and horrific depiction of what it's like to try to manage a large evacuation through a big fire. And I want to emphasize this risk is not trivial, nor is it one time. This is an annual major concern of the U.S. Fish and Wildlife Service, which manages Ding-Darling, and SCCF. Of critical importance is that the period of maximum fire risk, the dry season, is 100% consistent with the period of high occupancy at South Seas Resort. So we can't just say, oh, don't worry about a fire, it's not going to happen. And if it does, it's going to happen at a period of low occupancy, and there'll be 2 days' worth of notice. This is a very real and serious problem which the applicant has not addressed, and I have not seen addressed in any of the reviews that were done of this proposal. In closing, I want to emphasize this isn't NIMBY. The community is not saying not in my backyard. The community recognizes that the resort has to evolve, and it's in all of our interests for the resort to succeed. As Mr. Lappy just said, he's their competitor, but he wants them to succeed because it's all part of the larger infrastructure of the community. But we need that evolution to be done responsibly and respectfully of the environment and the community outside the resort gates. There's over a 50-year history of the resort and the community working together. The prior owners, and please note the plural there, owners, have cooperated and worked jointly to responsibly develop the resort. When the resort has needed reallocations or they need to do something different, there was consultation with the community, a discussion, and it was approved. Mr. Lappy echoed that in his experience with the community. But we've got a very different scenario here. The new owners want to disregard that history. They want to disregard standing contracts. They want to eliminate the 912 dwelling unit limit and the height limitations that have served everybody well for decades. They chose not to work with or even advise the community of their plans, but instead they engineered an end around and are trying to do a cram down on the community. As Mr. Goss just said, all they need is 3 votes. I think that is a fundamentally bad way for us to proceed in developing our environment. The fundamental issue here really is capacity. Does Captiva have the capacity to absorb the extra development that's being proposed? Can Captiva and Sanibel absorb the extra traffic, environmental burden, wastewater burden, and adverse event risk like a fire? If the assumptions are all sufficiently rosy and enough inconvenient facts are just swept away, it's very easy to get to yes. But as we've seen in New Orleans and South Carolina, the Carolina Outer Banks, and other areas, the lesson is that overbuilding in very fragile areas very often ends in tragedy. Very unfortunate aspect of these tragedies is that the postmortems frequently find that the risks of these tragedies were obvious and well known far in advance. They could have been and should have been addressed, but they were ignored. This proposal is going to affect the environment and the quality of life and the safety on Sanibel and Captiva for generations. At this time, we know the risks that this proposal generates and poses to us. And we can and we should address them honestly and comprehensively. That's not been done to date, unfortunately. The question is whether we're going to demand rigor and honesty in this analysis, or whether we're just going to go through the motions and tempt fate. Madam Examiner, I've attempted to draw attention to important questions, shortcomings, inconsistencies, and disregarded risks in the applicant's plans and presentations. I respectfully request that you carefully consider these observations in your deliberations. Thank you.
Thank you, sir.
Do you need a copy of this? It has a couple notes on it. If you want a clean copy, I can email it.
It's very helpful to her, especially when you, it's hard to get it all just sitting here and listening, and she has to actually get it verbatim, yeah.
Thank you.
Okay. Callie Johnson? Thank you for your patience.
Do I correctly understand that I have until exactly 4 p.m.?
Well, you can float over by a few minutes, but it
Okay.
takes us
I
time
just want to
to
be clear.
transfer all the data and, yeah. And if you don't finish, Callie, don't rush. We'll just start with you tomorrow.
I
for the
can't be here tomorrow.
Okay, well then go.
I will do my best for the court reporter, and I'm happy to share a copy.
Okay, good. That's helpful to her.
Okay. My name's Callie Johnson. Pardon my timing, I have to teach at FGCU tomorrow, so I won't be able to be there, or here, excuse me. Thank you for the opportunity to speak with you today. As one of the youngest people testifying before you, it is intimidating, but I feel it's more important to share my perspective. My family and I own and operate several businesses on both Sanibel and Captiva Islands, near where our great-grandfather homesteaded in the 1890s. I'd like to share some more information about myself and my family that are relevant to my testimony. More about who we are. We're a fourth-generation family business started in 1899 on Matthews Wharf in San Carlos Bay. That store was blown away, and they only found the safe in the bay. The new store, as Granddad called it, was retired when our current location, which is currently demolished due to Hurricane Ian, was built in the center of the island. That flagship, which is our only full-size grocery store, went 6 feet underwater in Hurricane Ian and is being rebuilt. We haven't started the physical rebuilding yet. We employed 120 people, and we plan to re-employ as many of those people as we can. I can't decide what is more sad after Ian, having to fire our entire staff or our inability to serve our community. We continue to operate the island store on Captiva. It is a third of a mile from South Seas. We try very hard to offer fair pricing, and my mom is known as the Sandwich Lady, lovingly. I'm also a proud member of the Captiva Civic Association as a business member. We plan to open an interim store later this year on Sanibel at Rabbit Road, and that will be called A Bit of Bailey's because we are only going to be able to offer a little bit of what we used to be able to offer at our full-size store while we rebuild. Why do I care? I'm a community member, not just a resident. I contribute beyond just my personal and business taxes. Among many other roles, this year I am the past board chair of the Chamber of Commerce. I had the honor of serving as board chair during Hurricane Ian and again during the beginning of our recovery. I'm a hardworking young professional, proud to afford a small home on Sanibel. Ironically, the former owner informed us when we bought it that it had never flooded since it was built in the 60s, its ground level. Without getting into the details, I have bought the same exact refrigerator 3 times. I will share a little bit more, especially more than I would about myself personally, because I think it speaks to the gravity of this matter and how seriously that I take it. I am a woman who has had to delay marriage because of Ian's financial impact. Ironically, we got married come hell and high water 2 weeks after Milton. I imagine you're aware it takes longer than 2 weeks to plan a wedding, so we didn't plan on Milton showing up. I'm a wife now who has had to delay children because of Helene and Milton's financial impact. It would be irresponsible of me to have children at this time when I need to be able to afford to live my home. The house my great-grandfather built in the 1890s, where my grandfather was born, where my mother grew up, only 2 feet off the ground. It's still standing because it's surrounded by low-density housing and dense vegetation. That same home, my great-grandfather invited the community to stay in the 1926 hurricane. That same home is where my brother was married after Hurricane Ian, and he and his wife now have my future niece on the way in July. due in July. My family and I chose to carry this family legacy forward, and we choose it every day. All of this is to say we take great pride in doing the right thing, even when it's the hard choice. Thank you for being patient while I help you understand my perspective. The reason people visit our islands is because of the low density, low height, natural environment. The number of visitors and residents on the island directly correlate with my sales. Residents on Sanibel drive to our store on Captiva because of the limited options available to them. I don't know your familiarity with the grocery business, but the profit margins are infamously low, and I wish I could tell my great-grandfather that. We depend on high product turnover just to break even. I insist on charging a fair price for our customers. Our major costs, which are staff, refrigeration, and perishable food, stay the same regardless of how many people walk in the door that day. I would benefit from the proposed South Seas changes. The reason I shared with you about myself is so you know how much that could benefit me. But I don't want that to happen, and here's why. These sacrifices are not worth selling the soul of our islands. Sacrifice quality of life, which would be immediate for me, including example of even more than already hellacious traffic. Sacrifice life safety, sacrifice water quality. I'm a spear fisherman, and the plant in the mangroves may or may not effectively treat sewage, and I know that that affects the fish that I am able to take home. Sacrifice environmental integrity, as outlined already by SCCF. This will sacrifice everyone's bottom line when nobody wants to visit or live here. To use a phrase that was likely invented by a grocer, the juice is not worth the squeeze. I had to make a hard choice to come here today. I worry about the repercussions of speaking to you today. I moved or missed hours of meetings to rebuild our flagship store, and if I am here, I cannot stock the shelves or check people out, which the community will tell you I do often. I'm asking you to make a hard choice too, not to change anything. Please recommend the Commission respect and enforce the existing community plans that will protect our islands, so the 5th generation of my family can continue supporting and caring for our community as we have since 1899. Thank you for your time and consideration.
Thank you.
Is there somewhere you would like me to send this?
Are there questions of this witness? No questions. Thank you. If you would like to send a copy of that, when we close the hearing, you can speak to Debbie and you can send it to her directly.
Okay, thank you.
And thank you for that, because it's a help. Okay, we're going to conclude the hearing today. We will resume tomorrow. I understand I'm going to get a new witness list tomorrow for members of the public wanting to speak, and so I can't say who's going to go first, but I will see you here tomorrow morning at 9 o'clock.